Speaker.
Member for Superior.
Thank you very much, Madam Speaker. I join this debate on an act to provide for a tax amnesty in relation to certain revenue laws, to amend the Retiring Allowances Legislative Service Act, the President's Emoluments Act, excuse me, the Judges' Salaries and Pensions Act, the Freedom of Information Act, the National Insurance Act, the Central Bank Act, and with a new amendment on top of these amendments, also the Companies Act and the Non-Profit Organization Act. So a bill with about 10 clauses, a schedule. Even though the ink had dried on that, we were given an amendment to the amendments. And the conjoint effect of this bill is really making amendments to almost 19 statutes, 10 of which are pieces of revenue law. So what we have here is a complete hodgepodge, a mishmash of disparate policy decisions materializing into, as I say, 19 statutes being amended by this one bill. And I want to agree and go even further, but first to agree with Messrs. Dumas and Daly. When they spoke about this bill, they said, and I quote, that they were left with an overall impression that legislative craftiness and stealth are at work, given the haste with which the legislation is being treated, and when one considers the significance of the items thrown together. Matters that are totally unrelated. Freedom of information, dealing with tax amnesties, dealing with pensions, yeah? Dealing with the companies law. All of them dubbed in page 8 of the bill. There is attached the certificate of the Speaker. Madam Speaker, I respectfully enjoin that you do not put your signature to any certificate, because this is not a money bill. It's not a money bill.
I want to say to Member for Superior that the certificate is a matter for the Speaker in the Speaker's sole discretion. If members want to talk about a money bill and what is a money bill, but as far as the certificate, it is something that is in the sole discretion of the Speaker, and I ask members to stay clear of that, please. Thank
Certainly, Madam. So that this bill, given the wording of the certificate, which is in your discretion, in your leadership's discretion to sign or not to sign, it is our respectful view that this is not a money bill and therefore is not deserving of any endorsement of a Speaker's certificate. And I'll explain why in a moment. But as I want to contribute on this, there's so much to say because it's, as I say, disparate pieces of legislation. It's almost like deja vu. I'm reminded here where we were in 2009. It's like being there all over again. When there was a PNM government, just like now, which had totally lost touch with the population. Totally lost touch with the population. And really, history is repeating itself. Again, we hear statements being made inside of this parliament, and they seem totally unrelated to the reality of people suffering outside of the parliament. Madam Speaker, I heard the members for San Fernando West, Diego Martin Northeast, dealing with certain issues related to pensions, and one of my colleagues will handle that in a short while. But today it is like the government is trying to run from the people and from the issues affecting people. But we want to say they can run, but they cannot hide. We were found out. So here we are, first of all, with all these various pieces of legislation. And the first point is obviously there have been no consultations on the matter. Absolutely no consultations. On legislation that is far-reaching, absolutely no consultation. So we have a statement from the Law Association, June 9th, Law Association, which says, and I quote, the FOIA has become a cornerstone in civil society's effort to hold public authorities to account, and they ask that the AG postpones debate and allow for public comment. There was a statement of 30 NGOs, 30 civil society groups, not one, 30 civil societies groups, saying that they call on the government to withdraw Clause 7 of the bill and give ample opportunity for public review to discuss and comment. They say further, we are firmly of the view that public consultation is essential. We are of the view that such far-reaching alterations of the FOIA should not proceed without full public discussion and consultation. So all these groups and many others have come out in asking for widespread consultations. And then what happened? The Attorney General holds a press briefing and he tells the public nothing to consult is reported in the Newsday, Wednesday, June 12, 2019, nothing to consult on. This was the AG's comment when asked about the calls being made. And as one person put it, and this I'm speaking of the Managing Director of the Law Invest Institute, and I quote, civil society asked that Arawi withdraw the amendments and facilitate consultations. Continues, he has unilaterally decided that what people wanted was a reduction in the length of time. And therefore he says no consultation, and they are still calling for consultations and holding their hands on the Clause 7, so no consultations whatsoever. Now, I have looked everywhere. I have been able to identify 105 pieces of freedom information laws in the CARICOM, in the Commonwealth, and of course in the rest of the world. And the AG seeks to use one of those, which is Guyana, and talks about Guyana having a 60-day. May I say, Madam Speaker, my reading of the 60 days is first you must reply within 30, and you can extend to 60 days. But even that, unlike what the AG is telling us in the Freedom of Information, Clause 7, all we want is an extension of 2 weeks. That is not true. You are saying the public authority will be extended to 45 days, and then there's an additional 30 days to be given while the AG is conducting his review. So that's 75 days, Madam Speaker. 75 days.
Can you try to contain your comment, please? Member for Superior.
Thank you, Madam. So I will very quickly go through this. Antigua and Barbuda, 20 days limit, 20 days extension. Bahamas, 30 days limit, a total of 30 days, no extension. Belize, a 14-day limit, no extension. Wow. Guyana, 30 days to acknowledge, 60 days to respond, which is the one that was used by my colleague. Jamaica, 30 days limit, 30 days extension. St. Lucia, 20 days limit. Cayman Islands, 30 days. St. Kitts Nevis, who just passed theirs in 2018, 20 days. St. Vincent and the Grenadines, wait, I'm getting to very large populations at the moment, so don't get too worried. St. Vincent and the Grenadines, 30-day limit. Australia, 30-day limit. Bangladesh, 20 days. Bermuda, 28 days. British Columbia, 30 days, 30 days extension. Canada, 30 days. Cyprus, 30 days. Fiji, 20 days. India, 30 days. Kenya, 21. Malawi, 15. Malaysia, 30. And it continues, Madam Speaker. Maldives or Maldives, as they're called, 21 day with a 14 day. Malta, 21 days. Mozambique, 21 days. Malta. New Zealand, 20 days. 20 days. Nigeria, 7-day limit, 7-day extension, 14 days total. Pakistan, 10-day limit, 10-day extension, 22 total. Seychelles, 21-day limit, 14-day extension. Sierra Leone, 15-day limit. South Africa, 30-day limit, 30-day extension. Sri Lanka, 14-day limit, 21-day extension. Tanzania, 30-day limit. United Kingdom, 21 days limit. Vanuatu, 30-day with an extension of 30 days. Albania, 10-day limit, 30-day extension. Argentina, 15-day limit, 15-day extension. Armenia, 30-day maximum. Azerbaijan, 7-day limit, 7-day extension. Belgium, 30-day limit. Bosnia-Herzegovina, 15 days. Brazil, 20-day limit, 10-day extension. And it continues, madam, throughout 105 pieces of legislation that we have been able to access online. And in not one of these 105, is there an insertion of the Attorney General into the process? None whatsoever. Absolutely none. In the majority of cases, the authority, the body to make the decision is the public authority, the public body. That is the one. And in some cases, they have someone known as an information commissioner, who is an independent office where you can go to make a complaint. If they don't give it to you, you go to the independent commissioner first. In our laws, we have two ways we can make a complaint. We can either go to the ombudsman to make a complaint, or we can go through the AGR, through the Freedom of Information. The judicial review, you go to the High Court. So that's the first thing with this. A comparative legislation gives us no model for us to take a retrograde step that we've been asked to take in this parliament to change our laws by giving more time for it. Yes, and of course misleading in that regard. So let's look at the bill itself now. Again, in the bill, I have identified, in my respectful view, what I am speaking of as constitutional aberrations, constitutional violations. The first has to do with what I raised initially about the certificate of the Speaker.
Member for Superior, I'm not allowing any discussion on the certificate of the Speaker.
Madam Speaker, I would like to say it's not a money bill, and that's the only reason it arises. I cannot use... Hey, what's wrong with you?
Who you talking? You think Marcel here?
I would ask all members to contain their tempers. Member for Superior, as I said before, and I'd like to caution all members, it is only in the opinion of the Speaker. So members may have their opinion, but I'm not going to allow debate on something that is in the sole discretion and determination and domain of the Speaker.
I would like to say, given the provisions of this bill, the bill is not a money bill in accordance with the Constitution. It's not a money bill.
Superior, member for Superior,
Yes.
it appears that you have determined to flout my ruling. As I said, if we are true to these very provisions you have quoted, it says, in the opinion of the Speaker. I'm very sorry, whoever else has another determination. I'm speaking about the Speaker's determination. I'm not allowing that. Continue.
So section, looking at the Constitution, there are provisions relating to section 63 of the Constitution, 64 of the Constitution, 65 of the Constitution, and of course, section 66, which defines what is a money bill. The Constitution tells us what is a money bill in section 66.
Supreme law of the land. 66. The supreme law of the land, above the standing order.
Section 66 of the Constitution deals with provisions relating to section 63, 64, and 65. In section 63, 64, and 65, money bill means a public bill which, in the opinion of the Speaker, contains only provisions dealing with any or all of the following matters: the imposition, repeal, remission, alteration, or regulation of tax, the imposition for the payment of debt or other financial purposes, the grant of money to the state or to any authority or person, the appropriation, receipt, custody, investment, issue, audit of accounts, the raising or guarantee of any loan or the repayment thereof, subordinate matters incidental to any of the matters referred to in this subsection. So what happens if a bill is deemed a money bill? We have seen in this bill that there are provisions dealing with money, and there are non-money provisions, FOIA, central bank, companies, and so on. what happens in our Constitution if a bill is deemed a money bill or not a money bill. And it has serious implications, because if the bill is deemed to be a money bill, then the Senate, whether it receives the consent of the Senate or not, it can be presented to the Excellency of the President for assent. So in other words, if a bill is a money bill, the Senate will not have to vote on it. There'll be no vote, there'll be no amendments whatsoever. And it says it in the Section 64 of the Constitution.
I have, 1 minute, please. I don't think you have contributed yet to the debate, but as soon as you indicate in a proper way, you'll have my ear. Member for Superior.
Section 64 of the Constitution tells us, where a money bill, having been passed by the House of Representatives and sent to the Senate at least 1 month before the end of the session, is not passed by the Senate, without amendment. In other words, no amendments. And even if it is not passed by the Senate without amendment, within 1 month after it is sent to the Senate, the bill shall, unless the House resolves otherwise, be presented to the President for assent, notwithstanding that the Senate has not consented to the bill. In other words, a money bill is one that would be voted on only in the House of Representatives. There would be no input from the Senate, and the Senate would be irrelevant. And I know there will be some senators there who will be very upset with some of these clauses, because I recall when we attempted in 2014, I was stopped in my tracks, the government was stopped in its tracks, and I listened. We brought a bill to amend the terms and conditions and pensions and so on of judges, of parliamentarians. And the outcry was so great that I stopped it. We pulled it back, did not proceed. And there was an independent senator, Senator Vera, whose comments were very scathing with respect to what was happening then, and I suspect he will hold the same kinds of positions here. So there will be those in the Senate who will object, not necessarily only on my bench, but on the other bench, because we have the Hansard of Senator Vera totally against legislators dealing with matters. So let's look at the constitutional issues that arise in this. First of all, can I get it down? Or did I take it already? Well, that's interesting. Here we are. First of all, Senator Vera raised then, and I raise it today, as others have raised it in the media, what is the issue, constitutional issue, and the role of the Salaries Review Commission. Chapter 11 of this very Constitution established a Salaries Review Commission to look after salaries and terms and conditions of high officials in the state. And it was interesting when I was doing research on this. This 1962 Constitution did not have a SRC, did not have a Salary Reviews Commission. It was only in the 76 Constitution, for my research, that we established in our country the Salaries Review Commission, to consist of a chairman for the members appointed by President after consultation with Prime Minister and Leader of the Opposition. Excuse me. The members of the SRC shall hold office in accordance with Section 126, and the SRC shall from time to time, with the approval of the President, review salaries and other conditions of service of President, holders of offices referred to, some other high public servants, members of Parliament, including ministers of government, parliamentary secretaries, and the holders of such other offices as may be prescribed. The report of the SRC concerning any review of salaries or other conditions of service submitted to the President, who shall forward to the Prime Minister for presentation to Cabinet and to be laid in Parliament. So here is a constitutional independent body to look after terms and conditions and salaries of office holders who are sitting here, former legislators, judges, ministers of government, and cabinet ministers, non-cabinet ministers, the president, etc. I find it passing strange, but in the amendment, we are seeking to do two things. To amend the definition of salary to mean not just your basic salary, but to now include a housing allowance and a personal allowance. And the second thing that this bill is attempting to do is to index the pension, that is to say, to protect against inflation. Well, let me say, first of all, that given the thousands of people in this country have lost their jobs, they have no jobs, given the hardship and the poverty, we cannot in any way condone what is taking place. No way. And then a member on that side gets up to tell us that the Pensions Act for civil servants and so on, that Pensions Act has a precedent to use allowances. You know, Madam Speaker, it is not for all the allowance, you know. It's only all your allowances must not come up to more than 1/6 of the salary. Must not come up more than 1/6 of that civil servant salary. A civil servant getting $10,000, for example, 1/6 is what, $1,500? $1,600. Of 1/6 of their salary. I'll give it to someone to read the section for you in the present Pensions Act. So ordinary police officer, for example, a fire officer, they don't have that provision, Madam Speaker. They don't. And secondly, you know what they don't have either? Indexation, the protection against inflation. So imagine one of these ministers, oh, and by the way, none of our members have any allowance whatsoever on this side. Huh? So forget us. On that side, you're now going to add housing allowance and personal allowance. I find it passing strange that they would mention to add personal allowance when at the moment there's absolutely no personal allowance for anybody here or president, prime minister, no personal allowance under the SRC. There is no provision for a personal allowance. And the question, begs the question, why? Is it that they have sight of a draft SRC report we have not yet seen? Is it that they have sight of that draft report that we have not seen? And I want to raise in that connection the fact that somewhere a couple of years ago, a firm was appointed to carry out a job evaluation exercise for officers under the purview of the SRC. They started their work, and to date they have spent, to pay this consultancy firm, this government has spent $8.8 million. Estimated expenditure as at this time in 2019. $8.8 million to conduct this job evaluation exercise. Why then will the government not let the SRC complete its work? Because I understand the report is ready. This job evaluation exercise is almost complete, should come in before the year ends. Why is the government rushing to raise their pensions? Why? When it is that the SRC has to undertake, I remember they came to interview me, they might have interviewed other members of parliament. They interviewed everyone, and they will complete this report. Why is the government rushing to put these salaries into place, these pensions are into place, when this SRC report and the $8.8 million worth of work, research has been done? So I raise the issue of the constitutional role of the SRC in respect of the increases in pensions that are being put forward. The second issue I have is with respect to the Clause 9, which seeks to amend the Central Bank Act. And I know the Honourable Minister quoted from the Jamaican Act to say that in Jamaica there is a Jamaican Act which deals with the fact that the Central Bank of Jamaica has to provide information and so on. And therefore, our Clause 9 seeking to give Minister information is not unprecedented. But, I would have thought the Honourable Minister would have done a little more research. You see, because there is currently before the Jamaican Parliament, before a joint select committee, to give to the central bill, giving to the Central Bank of Jamaica more autonomy. What? The Finance Minister quoted Section 7.2 of the Jamaican Act, which gives the Minister of Finance the power to approve the salary of the Governor of the Central Bank. But the 2018 bill before the JSC proposed to remove this power of the Minister of Finance. And so we are looking at, I come to that issue in a minute, Clause 9. Clause 9 in our bill intends to amend Section 56 of the Central Bank Act And that amendment is to allow for the following to happen. First of all, it says 6 of the clause here, Section 56 of the Central Bank Act is amended by inserting after subsection 5 the following subsections. 1, 6, you need to put in 6. It says, notwithstanding subsection 1, the bank shall, within 7 days of receiving a written request from the minister, cause to be transmitted to the minister such information as the minister may specify in the request regarding salary and terms and conditions and so on. It is ironic, Madam Speaker, in my respectful view, that here it is a minister is saying, give me information in 7 days. But when you come to freedom of information, wait for 75 days. Wait 75 days. Wait 75 days. Minister must get it in 7 days.
Hypocritical.
But then, in the very bill, you want to extend the time
30 to 75.
to 75, from what was 30 to 75 days. And so, I will not go into a constitutional dispute with my colleague from Diego Martin Northeast, but it is my respectful view that this clause 9, in which the minister is saying, give me information, not only about present central bank workers, but past. My good colleague here was a central bank worker, remember, for Pointe-a-Pierre. Tells me work with the central bank at some point in time. I can't say. The member for Pointe-a-Pierre worked as an employee of the central bank. Yes? They're so unkind, huh?
So
I
unkind.
have nothing to say, just stay quiet. So he's going to get for present and past. Doesn't matter how, doesn't say how far back. Well, how many years backwards. He must get, the minister requesting, must say, the salary and other terms and conditions of employment of the governor, deputy governors, directors, officers, and employees. So that's everybody, tooth bagay. The organizational structure of the bank. The number of current or former officers and employees. The number of filled or vacant positions in the organization structure. Such other matters related to employment of staff as the minister thinks fit. And a request under this may relate to a period before the coming into force of this subsection. Retroactive. So this is really aiming to give the minister additional powers that could be potentially reckless in nature. It allows the minister to have critical and confidential information within 7 days. There is no allowance for any reason to be given for the request. In other words, a mere request can be submitted and the information retrieved without any protection. A mere written request from a government minister should never be into law to retrieve confidential information in this manner. And this, I know there's some on that side who do not believe in privacy rights, but our Constitution, again, is very clear that you cannot abridge any privacy rights. Here, give it to me. In the Bill of Rights, Section 4 of the Constitution, you cannot abridge any of these rights. No law, unless you're working with Section 54, which says if you're abridging, abrogating, or violating privacy rights, you need to get 3/5. So when they're boasting out there, they don't need a constitutional majority for this bill, you're wrong. You're wrong. You're breaching the Bill of Rights. You're breaching privacy rights in the Constitution. You are breaching constitutional right to privacy.
Privy consultant.
Constitutional right to privacy. By the minister requesting confidential information. That's what this bill is seeking to do. The minister will request confidential information. Yes? Confidential information that the minister is seeking to get about employees of the bank. That, I'm saying, is in breach of the Constitution. It cannot be passed in this Parliament by a supermajority. Then we come now to, this is for the SRC. Then we come to another area of what I respectfully submit is a further breach of the Constitution. The Attorney General is very clear in his presentation that you would have to list public authorities, and he listed many of them, and some, he said, they were not under the direct control of government and so on. But once funding came, he mentioned the Zoological Society, for example. Yes, all that is so. But there were very important public authorities that the member for San Fernando West failed to mention. If we look at Section 3 of the FYA, that act which the San Fernando West had done, we see that public authority means A, Parliament, a joint select committee of Parliament, a committee of either House of Parliament. B, the Court of Appeal, the High Court, the Industrial Court, the Tax Appeal Board, or Court of Summary Jurisdiction. E, the THA. F, municipal corporations, which are political bodies. Regional health authorities. Service commission established under the Constitution. These all are independent, autonomous bodies and cannot fall under the direction, control, or instruction of the Attorney General. It cannot happen. If you want to do that again, if you wish to.
Member for Superior, your original time is now spent. You're entitled to 15 more minutes, if you wish to wind up.
Thank you very much, madam. I will avail of the 15. So what we are saying now, the AG is telling us, don't worry, I am just going to say yea or nay. When they said it to me, after they said yes, I will review it and I could change my mind. I could say yes, give it to them. Or he could repeat the no. Well, that may be all and well and good for the Office of the Prime Minister, for the Minister of Finance, Minister of National Security, and so on. But is the Attorney General, when the Parliament has asked a question on the FYA, they say no. They have to then send it to the Honourable Attorney General. When he gets it, he says yes. He says yes, the Parliament is a public authority under Section 3A. And they're saying all public authorities must now send their refusals to whom? The member for San Fernando West. And then that member for San Fernando West, guardian or no guardian of what? You cannot, I'm saying, have him direct the Parliament what to say or not to say. So if the Parliament said, no, I'm not giving it to you, AG, what do you say now? He's not like the final arbiter, like a court of one jurisdiction, own jurisdiction. Parliament. And they send back here to tell this Parliament, madam, you have to give it to them. That cannot be right in the law. You see, it cannot be right in the law. You then have the independent Court of Appeal, High Court, Industrial Court, Tax Appeal, Court of Summary. Courts, the judiciary, the whole judiciary, and magistracy. Is the Attorney General going to tell them, sorry, you have to give it to them? Yes. You have, when they ask you something, judiciary says, oh, no. AG no come easy master with a stick. No, you have to give it to them. Secondly, service commissions are so deeply entrenched and insulated from any politician. Service commissions. And madam, from all the stats, if you look at them, the cases that have been filed in JR, for JR, for the FIA, all the cases, the majority of them are not super political things, madam. The majority of them have to do with little simple things that people have trouble with. They have to do with getting medical records. The majority are, in fact, for service commissions, where people have been bypassed for promotion. Bypassed. Yes, you can under the FIA. A person, I just go through the case, I'll find one for you. Right now...
Members, the crosstalk. Member for Superior.
Yes, madam. Obviously, they haven't read the statute, or else they will know that. Right now, there is a client who came in yesterday who talked about getting medical records with respect to the child who died at Mount Hope. Yes.
With blood transfusion.
Yes, with blood transfusion, to get those records in order to bring a case of wrongful death. So yes, so they're about medical records, they're about why it is that a police officer didn't get promotion. Ann and Ram Logan won a case just last week in the Privy Council. About that. What are you looking for?
It beat to them every day.
Yeah, the cases.
Cases.
I don't think he has it. It's over there.
No, not yet.
So, what do we say? I'm saying that you cannot give that power in this bill to the Attorney General to be inserted in this process. It is unconstitutional. It is a breach and violation of the Constitution. And I'll just quote one of them here. This is a judgment of Madam Justice Gobin. The case was Garvin Sukram and Conrad Barrow, Commissioner of Prisons, CV 2014-02199. And this was a case where the issue of separation of powers came up. And I quote from paragraph 34 of the judgment. There can be little difference between what Lord Stein described as characteristic features of democracies in Anderson and what he subsequently referred to as concepts invoked by the idea of a democratic state in Coriati. Now, Madam, just get of Coriati and the state, the issue that arose before the Privy Council in that case had to deal with the structure of the constitutions, such as ours, and the framework upon which we govern ourselves through the Constitution. And in Coriati, the Privy Council found that their Section 2, which is equivalent to our Section 2, basically it says Trinidad and Tobago is a democratic sovereign state. The exact words in our 2 found in the Mauritius Constitution, in the case of Coriati, the Privy Council said, listen, you know what that means? That means that there is a separation of powers. There is the judiciary, there is the executive, and there is the legislature. And that's the 3 arms of the state, basically, which is what we are getting to here when you give the AG that power as a member of the executive now to tell an independent body, such as a parliament or the judiciary, to proceed with something when they had originally said no. So the concepts defined are free elections, fundamental rights protected by an impartial, independent judiciary. The separation of powers are clearly characteristic features of democracies. I therefore hold, applying the principle of the judgment of the Privy Council, that the declaration that Trinidad and Tobago shall be a democratic state is not a mere preamble, that it is an operative and binding provision and constitutes a separate and substantial guarantee to the citizens of Trinidad and Tobago. What was this about? Oh, yes, yes. There's a case here, I said I would find it because I went through every single JR case on the FYA. Ramkisoon Raghu Kavita, in her personal capacity and her capacity of mother and next friend of Davin Khalil Raghu, born 3rd February 2017, intended claimant applicant versus the Ministry of Health, intended, and in this case, request for information, national policy on Zika virus and pregnancy by the Chief Medical Officer, Ministry of Health, guidelines and so on. Cost. The judgment was given, they won the case in this particular one, and
Madam Speaker, that case is sub judice.
Member for Cypria,
yes,
in
ma'am.
that case, I will not allow you to deal with that case.
Madam, I'm referring to a judgment in that matter given on the 5th of June 2018.
Is it on appeal?
I am referring to the High Court judgment.
If it's on
madam, which
appeal, I'm not going to allow you.
But the High Court judgment is a matter of public record. It is a
it's on
public document.
Cypria, if it's on appeal, I'm not allowing it.
Find another one. Anyway, the point is made that you can do judicial review. You can do FOI and so on for medical records. The second case I would like to refer to with respect to separation of powers. What time am I stopping? 45?
46.
Yes.
46.
With respect to separation of powers, and therefore you cannot do what you're doing in this bill to insert the AG without the special majority provisions. The second case I refer to is one that may be familiar to the member for San Fernando West. It is a case of Haridad Miraj and the Attorney General of Trinidad and Tobago and the Police Service Commission. In this matter, I appeared together with Mr. Anand Ramlogan, Jayanti Lakshmidiyal, Pariaksik Bailey, and Kamla Persad-Bissessar for the claimant. And this was a matter which took place right here in this Parliament.
And you won.
In the case of the Police Service Commission, yes, we won.
You won.
We won, yes. In this case, I'm one of the UNC lawyers, perhaps, I don't know. In this case, what was being challenged was the fact that government had brought to Parliament an order for the recruitment of a commissioner of police, deputy commissioner of police. And it was the service commission who had to do the recruiting. But government came in that subsidiary legislation, the order, to insert the minister into the process. And of course, the court held that that was totally unconstitutional. And the order was those provisions in the order were deleted because they were in breach of the Constitution. So likewise, should we proceed in this manner, we are heading down that slippery slope of unconstitutional activity. Oh yes, and there'll be a lot of costs. There'll be a lot of costs. That's okay. All right, I'll get these here now. So let's come to some of the things the Honourable Attorney General would have alluded to when he spoke. Talking about milking the system and costs. That is an indirect attack on the integrity of the judiciary of Trinidad and Tobago. And I say that because those costs, the applicant and the lawyers, they don't claim the costs and say, give me 1.7 million, 2 million, 3 million, 4 million. The costs are assessed by a judge. By a judge. And if you think those costs are too high, well, go and tell the judge that. Try telling the judge that. The judge is the one in the discretion. Same way we work in the discretion of the speaker here. When you bring a court case, you win the case, costs are awarded to you, and you don't decide. You go to a judge for the costs to be assessed. So this thing about milking the system and whatever, it is part of their own incompetence. We're losing the cases, case after case, and then quarreling when people get their costs. That is the way the judicial system works. You win a case, you are awarded the costs in the system, the judge assesses the cost. So the other point that the Honourable Attorney General talks about, the procedure that must be followed before an FOIA judicial review is filed. Members are now telling this country, misleading the country, telling the country on the 31st day, 30 days you had to do it. On 31st day, you file a judicial review. Nothing is further from the truth. Nothing is further from the truth. And the member acknowledged it, but they just slip and slide, slippery. Just slip and slide. Member spoke of it. The practice direction, which talks about pre-action protocol letters, Madam Speaker. You must give 30 days notice. And that notice, there's a pre-action letter. That notice is served on whom? The Solicitor General. I have a media statement here. I transcribed it. Honourable San Fernando West telling the whole country, you see me, I work very hard, thumping his chest. Every file that comes on the Solicitor General's desk, I go through every single file. But then the Solicitor is on the Department of the AG. And the lawyers, the practice direction, pre-action letters, the same FOI, you have to send a pre-action letter before you could go to court, gives you 30 days notice. So when the AG said if he had known about the Petrotrin and the Malcolm Joel witness statement, he would give them it. He would give it to him. Nothing is further from the truth. Nothing is further from the truth. So first of all, it doesn't happen on the expiration of the 30 days. When you get back your reply on day 30, if you get it back on day 30, on day 31, on day 31 you file the pre-action letter served on the Solicitor, who is in the Department of the AG, and that public authority requests an extension of time and so on. I want this Petrotrin matter, that AG keeps saying if he had known, the date, the 11th of March 2016, the FOIA application was submitted to Petrotrin, okay? Freedom of Information request. 22 April, Petrotrin refused to provide the statements. 11 May 2016, the claimant asked whether edited versions of the witness statements could be given, if you can't give all. 4 July 2016, pre-action letter sent to Petrotrin, and guess to whom? The same pre-action letter went to the AG's office. The person who collected was a Jonathan Henley, who signed on the return of service. Signed, Jonathan Henley. Wow. So, but saying you're not in the loop, and if you had known, look at his crocodile tears. You were exposed, you were embarrassed. And that judgment is what, this bill is like a knee-jerk reaction to that judgment in the Malcolm Jones matter. Claim of not being in the loop, that he could have advised Petrotrin when the documents were signed by persons in his office. And then he spoke about a couple of cases. I think I have to leave these for my colleague from Moropuch. The cases that the member of San Fernando West actually mentioned mention. There's one case where he talk about the fees is 1.7 million. Madam, that is totally untrue. No costs have been awarded in that matter for that. The matter is to be assessed. The matter is to be assessed by a judge. The judge has to assess the claim, so there's nothing. This was a case of Vijay Singh. 1.7 million in legal fees, the AG told the country. The costs have not even been assessed by the court. So you demonize Ramdeen and Ram Logan. Well, I just have 245.
It's frivolous.
Madam Speaker, 48-6.
I overrule. Continue, sir.
Yes, the Honourable Attorney General spoke about some other cases. My colleague will have to deal with them because time has run out. But again, all the cases that the Honourable Attorney General has mentioned today in his contribution, Vijay Singh, Daryl Hiralal. Madam, imagine you talked about one case, I think it was Hiralal, went twice and got what? How much money? 200,000. And a second. You know what happened? The court ordered. They asked for the names of the people who had advised the government to withdraw, to fire Jawala. They refused.
The speaking time is now spent.
I thank you for your time.
Member for the Martin West.
Madam Speaker, I thank you for acknowledging my request to join this debate to make a few observations. Let me begin, Madam Speaker, by identifying my profession. I'm a geologist, and in my profession there is no senior, there's no instructing, and there's no junior. And Madam Speaker, my observations and my position on these matters have nothing to do with the circumlocutions of law, because I do not pretend to be a lawyer. What I do know is that I have a duty in this job to protect the public interest. Lawyers have been known and continue to be known to be able to argue anything in any direction. The substance, the truth, even the logic of it doesn't have to matter. It is the ability to argue that sometimes wins the matter. And Madam Speaker, I am not here to engage these lawyers in this chamber about law. But I'll engage them on common sense, Madam Speaker. I want to talk first and foremost about the whole question of the grouping of the issues in a miscellaneous bill. The fact that the Minister of Finance has brought a miscellaneous bill, which we commonly call an omnibus bill, covering 3 or 4 or 5 items in the Parliament, all of a sudden is a wrong thing and is to be viewed suspiciously like a hand grenade about to explode in Trinidad and Tobago. Madam Speaker, let me say very clearly, next year would be, how many years or this year? I've been in this Parliament a long time. In fact, when I look at the publications of my speeches in the Parliament, I myself am amazed how long I've been in this Parliament and how much I've been involved in the business of this Parliament. And Madam Speaker, throughout my life in this Parliament, in public business, I have always known about miscellaneous legislation, where bills come covering 3 or 4 things. In fact, there's one particular bill where we are amending 17 pieces of law. Because to do what you want to do, you make the amendments. And if it makes sense to bring them all in one bill, you do that. I am not against my colleagues on the other side to see where they could score political points, stir up public discord, and even hatred, you know. I'm not against that at all. If they think that could work for them, fine, because this thing about cheap political points, there's no such thing as cheap political points. It's political points. If it works for you, it works for you. If it doesn't work for you, it doesn't work for you. If you think you can score points there, more power to you. But that does not deny me the opportunity to stand on what I believe is common sense and what is in the public's interest. So, Madam Speaker, the person who responded to this omnibus bill today is the member for Kuva South. And you had no end of trouble in trying to keep him away from the NIS repetitions. On numerous occasions, he had to be spoken to about repeating a particular point. And accusations, you know, the singular point I gleaned from his presentation is that the government's instructions, or whatever it is, that Venezuelans who are in Trinidad and Tobago and given an opportunity to remain here under conditions that we've set for a year by registering and being allowed to work, that they should not have access to the National Insurance Service. Because if they make payments to that National Insurance Service, they would be entitled to make claims. Madam Speaker, we on the government side have a duty to protect the public interest. That is our job. If the opposition does not want to join us in protecting the public interest, then they're free to do so. Maybe when they were in government, they were protecting the public interest. And if they ever come back in government, they will protect the public interest. But while they're in the opposition, they must not, by decibels, try to create sensible facts. Madam Speaker, let me explain to you the kinds of benefits that are available to persons who pay money subscribing to the National Insurance Service. Employment injury benefit. Anyone could claim injury benefit if you pay into the insurance service for a year. But these Venezuelans will be here for a year, so it means that they get paid for a year. But to qualify, right? And to qualify, you make a payment. Is it one payment?
Yes, one payment.
So you make one payment. You make one payment, and you can now claim injury benefit.
For a year.
Medical benefit, up to $28,000 per injury. Once you can claim injury benefit, and there's no minimum period of employment. Madam Speaker, if you're sick, the insured person who is sick and unable to work, the insured person must have made a minimum of 10 weekly payments for 13 weeks prior to the illness, and then you could claim benefits. So a Venezuelan could be here and make 13 weeks payment, and then proceed to claim benefits of the insurance service. Madam Speaker, maternity benefits. I saw a couple pictures of Venezuelans in the line, which they seem to be advanced in the family way. Very advanced. Maternity benefit. You make 10 weekly contributions of 13 weeks. And 6 weeks before delivery, you're entitled to claim maternity benefits. Madam Speaker, I am sure that the member for Kuva South is not saying to us that he doesn't want them to claim these benefits if they make the payment. But the law says they will be able to make it once they make the benefit. And he's saying that what he is seeing, Madam Speaker, my colleague from Kuva South, because we have said that they should not be allowed to make the benefits, those of us who are protecting the public interest, we are saying don't allow them to make those minimum payments and make these maximum claims. My colleague from Kuva South, he sees the other side of the coin. Because they will not be paying the insurance benefits, they'll be cheaper workers, and this is a ploy to give the business community cheap workers at the expense of the people of Trinidad and Tobago. I conclude by saying, any person who is seeing this in the public interest will see that it is the public interest we are protecting by preventing them from making it, and not the other way around. Not the other way around. We are in conspiracy with no one. And persons hire people to suit their businesses and who work well for them. We are not here to dictate to employers who they should hire. And we are responding by having Venezuelans here to a crisis in Venezuela where our nation is making what some believe is a minimum contribution. What we consider is a major contribution. And that is just a matter of circumstance. So these conspiracies and devils that you're all seeing in every behind every tree, it's in your own head. It's in your own head. There's no conspiracy. It's a common sense decision to prevent them from making claims after making minimum payments. So I don't think that my colleagues really believe what they're saying, but they're saying it to incite the population. Deliberately. Some of them are lawyers, some of them are senior counsel, some of them are all kinds of counsel. Bush lawyer, fireside lawyer, all kinds of things. And they're saying it just to incite the population. We cannot extricate ourselves from the impact of the Venezuelan situation, but they organize people to come to the parliament to shout, Rowley must go, and they couldn't see me going to parliament. I'm going to parliament. You don't have to shout at me. I'm going here to protect the public interest. Madam Speaker, lawyers can argue in circles, argue for and against on the same issue. Somehow, the death of Malcolm Jones and Petrochin stands out to some people as a piece of dry wood in a stream that they're drowning in. And if they hold on to Malcolm Jones, they will survive the drowning. Madam Speaker, when Petrochin, a state company, refused to provide information in that Malcolm James, that Petrochin business matter, it was not the government of Trinidad and Tobago that said, don't provide the information. In fact, I'm head of the government. I only found out when I read the papers. And since then, it is all clear. Petrochin as a company used its right as a company to say no. At the time when Petrochin did that, and even up to now, my colleagues on the other side are still saying that that was a wrong decision. But of course, they are using it to accuse the government of hiding information and being in all kinds of conspiracies to protect Malcolm Jones from his $1 billion claim, even though he's dead. All kinds of things you're hearing because Petrochin did not provide the information in its own right under the Companies Act advised by its senior counsel. And that's how it was until a few minutes ago, when senior counsel from Superior said that the amendment that we are making here, which gives the Attorney General an opportunity to prevent an unnecessary rejection, which could trigger a lawsuit and which could result in taxpayers paying money, that is an infringement of the right of the decision maker who is making the decision to not give it. Madam Speaker, that sounds so convoluted. With your permission, I want to repeat it so the public will understand it. In one breath, when a state company refused to give it, all the argument from my colleagues is that that was a bad thing, it should never have been allowed, and then they use that refusal to infer all kinds of conspiracy theories. And then in the next breath, the leader of those on the other side, senior counsel, come in today to make points and to make case, like a high school argument, saying that the new arrangement that we are proposing will infringe on the right of an entity to say no in its own right and not be subject to any interference on the Attorney General. So on one side of your mouth, they must be able to say no and stand on that no. But on the other side of the mouth, you're saying you should have superseded Petrochin's right to say no. Because if you don't do that, we'll accuse you of conspiracies and all kinds of wrongdoing. What side are you on? What do you really believe? It can't be both. It's either or. It's either an entity has an inherent right to say no, and you accept what they've said in their own right, and then don't go on to accuse the government of not making them give it. We've had volumes of newspaper articles and television commentary and public platform statements that Petrotrin didn't give the information because the government stopped them from doing it. Even though we tell you a million times, we were never involved and there's no information showing the government being involved in a company in its own right saying no. And it is because of those exposures. I, as head of the government, Madam Speaker, said to this country, all over the government system, there are people who have this right to deny the public the information that is being sought. And if you don't find out, and after they say no, you create the environment for the famous and infamous lawyers to sue the state through the Attorney General, and once the suit is filed, the taxpayer now has a major liability. A liability which could have been prevented if the Attorney General was made aware of it and the no was somehow made into a yes if the circumstances warranted that. Madam Speaker, what is wrong with that? What is wrong with the Attorney General having the right to look at it and make a facilitation to say yes when the entity already had said no? Today, the opposition leader argued that the entity must be allowed to stand on its decision without let or hindrance. That might be so in law, but in terms of who is paying the taxpayer, that don't make no sense. Because if you could avoid the lawsuit and the legal fees by simply providing the information, why do you want to keep the loophole so the lawyer could sue on the rejection and then come and milk $1 million? And as for that $1 million, you all come here this evening to confuse us about cost and bill. We know the difference between cost and bill. And you are making a case for a pre-action protocol for $1 million. I stand here to represent the taxpayer, and I call that rip-off.
Robbery.
Madam Speaker, there's one, that particular Petrotrin matter that they hold on to for their political life. One particular lawyer wrote a pre-action protocol where a pre-action protocol is simply a letter saying, I'm wronged in this way, I intend to sue you, what do you have to say about it? You have 18 days, how many days to respond because I'm going to sue you because I feel I'm wronged. A letter. And it was no judge was involved in that. It was a claim made to an office, and the public officer authorized a payment of $1 million for a letter. And if that is what you all are supporting, okay, let it be known, let it be said that we on this side, we are not supporting that. And with respect to the involvement of the law, a bill can be presented, Madam Speaker, for a matter in the state sector. A bill being presented, and the bill be paid without any recourse to the law, to the court, because the matter could have been withdrawn from the court, and the lawyer's bill is still presented. That is what is going on. So to come here this evening and say that all those matters being paid by taxpayers have judicial oversight, and it's the judge that's doing it, poppycock. It is bills being put to public officers, and many of them have gotten into trouble for doing it, Madam Speaker, because we've only just begun. Yes, sir. So, Madam Speaker, they've riled up the whole country. 47 groups say, withdraw the bill for consultation. How many groups they have in this country? 407,000. 47 say withdraw the bill. Madam Speaker, we are here not to fight with anybody. We are here not to beat down anybody. We are here for one purpose. We are here to prevent taxpayers from being exposed to unnecessary lawsuits where taxpayers are made to pay money because there is a gaping loophole in this matter. The Attorney General outlined it this morning. Once a denial is given, when a request is made to a public entity, the person who has made the request has the right, which remains uninfringed, has the right to seek recourse of the court by judicial review to have the court examine the rejection. That remains in place. Once the matter goes to court, the court then says, get the Attorney General informed. So in any case, the Attorney General is going to be informed in the matter because you sue the Attorney General when you sue the entity.
To decide if he come in the case.
But, Madam Speaker, by not having the opportunity before you reach that stage, all that we are preserving, all that they are defending is the opportunity for a lawyer to file a lawsuit while the Attorney General's office remains ignorant of the denial. Madam Speaker, all we are here to do is to say, let the Attorney General be informed, because that, as far as we are concerned, is the only place where the public interest can be preserved, where we can avoid the lawsuit being filed. Exactly. Because once the lawsuit is filed, the taxpayer exposure to huge claims for cost payment to the lawyer has already been triggered. What is wrong with that? So all these discussions about how the democracy of the country is being destroyed and the right to get information is being destroyed. Madam Speaker, as head of the government, I've heard those arguments. We came with a bill to the House asking for an extension of the time that the public entity will need. It is now 30 days in law. We had said, okay, 90 days, extreme. In the face of public commentary, we said, okay, 45 days. Give them 2 more weeks so that we can more completely give the information. They're still carrying on. Madam Speaker, now, as head of the government, I'm instructing the Attorney General, let the 30 days stand. Right? Let the 30 days stand. Because that is not the primary objective here. The primary objective here is to prevent the loophole where lawyers dig out taxpayers' eye, and that stands. The government stands with that. That's what we came here for. We came here to prevent the Attorney General from being in the dark and not being able to intervene to protect the public from being sued in situations where the matter could be dealt with before it goes to the court. Madam Speaker, we can disagree on that. It is clear that the government sees it that way. There are others who see it differently. We disagree on that. Madam Speaker, I've heard my colleague from Siparia say she looked all over the world. And nowhere is anything like this.
Except Guyana and a whole set of...
Well, all the exceptions don't seem to matter. But, Madam Speaker,
Jamaica.
The reason why we are doing it in Trinidad and Tobago is that we look all over the world, and we have seen nowhere else in the world where lawyers are so exploiting the public.
What is her track record?
This morning, they talk about data, Madam Speaker. The data showed that it was about a 0.7 or a 0.8 or anything less than 1% of these matters that were going to court for judicial review. The minute they went into opposition, knowing the loophole being there, it jumped to 18% and growing from under 1% to 18%. Madam Speaker, that kind of rise is a serious albatross around the neck of the taxpayer. And what they're asking us to do is to leave it so.
Let them milk it.
We are saying, no, we're not leaving it so. We have the authority to close that loophole, and we will do so today. And as for consultation, the AG asked, what are you going to consult about? To tell me that we should leave it so that the lawyers will continue to exploit us? We have seen it, we know it, it's there. This is the data. And all we are saying, there's a loophole. We have heard today from Siparia, it is not a loophole. It is how the justice system works. But we are not unaware of her position, to Madam Speaker. It was this same member for Siparia who was informed by the AG office what was happening with prisoners and their lawyers digging out taxpayers' eye, milking taxpayers in a similar fashion, and did absolutely nothing to put an end to it, Madam Speaker. Today it is known as Prison Gate. Today, Madam Speaker, I as Prime Minister of this country, I am now made aware of what is going on in that loophole in FOI matters, and I have instructed the Cabinet to close the loophole. And Madam Speaker, everyone after that is free to go to the court and say that we have done it incorrectly, and if the court so rules, then so be it. But in the meantime, we will intervene to block that loophole that is being exploited at the expense of taxpayers of Trinidad and Tobago.
Yes, sir.
Madam Speaker, another matter that was beaten here today was the whole question of the sanctity of privacy at the central bank.
Nonsense.
Madam Speaker, as I told you earlier on, lawyers could argue one thing on Monday and argue something else on Friday. And I'm not anti-lawyer. I sleep with one. I have three in the, I'm as 3 against 1 in the household. My wife, my daughter, my son-in-law, they're all lawyers at the kitchen table. I love lawyers. Home. I respect lawyers because I respect lawyers because they can do things that the rest of us don't do. I went to London to meet, while I was passing through London the other day, I met with nationals one night just to interact with them and so on. And one person came, and the biggest problem that person had was they were paying a lawyer in Trinidad umpteen times. The lawyer wouldn't go to court. They had to come down here and take the lawyer to the disciplinary committee. So these things happen. But let us just say that the lawyers can tell you whatever you want to hear. Madam Speaker, in April 2015, we were in the opposition then. My colleagues at the SL were in the government. As opposition members, the following question was asked of the central bank: to name and the qualifications of persons employed by the bank between 2012 and 2014, and the process and criteria utilized by the bank to employ these people, and the position that such persons are appointed to by the bank in their current position. An opposition member filed that. The Parliament cleared the question, it was put on the floor here. And the bank replied, and I quote the reply. This is the government, members of the other side, speaking for the government. The central bank has reviewed the matter and notes that its confidentiality obligations under the Central Bank Act, Chapter 7902, are quite broad and extend not only to the affairs of any financial institutions or person registered under the Act, but also the affairs of the central bank itself. The central bank knows that it's obligated to comply with these very strict confidentiality provisions under threat of criminal sanction. And therefore, central bank claimed confidentiality and couldn't tell you who was working there, what criteria they used, and what the people are doing at this point in time as against what they were doing in 2012. There's a general conversation in the country now demanding 100% absence of confidentiality. But the same people who are leading that charge came to the Parliament and said the central bank must be a cloistered place where they can't tell you how many persons they hire, when, or even the salary. And Madam Speaker, that was under a UNC government with question asked by the PLM opposition. The same or similar question was asked in April 2019
By the UNC.
by a UNC member of Parliament asking about the compensation package paid to the governor of the central bank. In this country, you know the package for the president, the prime minister, and everybody else on the government payroll. But somehow, in the Parliament, a question is asked about the package for the central bank governor, asked by the UNC, and of course, using the precedent set. This is confidential, and it says, and I quote here again, by another minister of another government, this minister in this government, except insofar as may be necessary for the due performance of its objects, every director, officer, and employee of the bank shall preserve and aid in preserving secrecy. So the secrecy of the salary is something that is connected to the due performance of your duty. That's all we're being told. And this government says there's certain information that can come from the central bank which ought not to be treated as confidential.
Like every other bank in the world. Because taxpayers pay it.
And the Minister of Finance is saying, by research, all over the world, central banks can make that available. But, Madam Speaker, my colleagues on the other side are saying, in one breath, when they're in the government, that you want confidentiality. When you're out of government, there should be no confidentiality. The central bank, bastard of confidentiality, this government is saying that there is certain kind of administrative information, certain kind of administrative information that could be made available.
Correct.
And my colleagues are saying, no. As a matter of fact, one expert is saying today that the independence of the bank is going to be destroyed. So if we find out that central bank has hired 2,000 people down there and are paying them whatever they want to pay them, we just have to keep quiet and do nothing because we can do nothing about central bank. That's what they're telling us. And if we try to even find out, then you are destroying the confidentiality of the bank. The confidentiality of the bank with respect to banking business, yes. But these questions filed by two governments have nothing to do with banking. It's all administrative. And if members on the other side don't want to support that, then you are being disingenuous and being hypocritical. Because in one breath, you want total confidentiality where it will obviously damage the country. But in a matter like this, opposing for opposition's sake, you stand with the central bank in preserving confidentiality.
Member Fidigo Martinez, the original time is now spent. You're entitled to 15 more minutes to wrap up your presentation.
Thank you, Madam Speaker. I thank you, Madam Speaker, for the extension. And you know, Madam Speaker, on this particular matter, just to show you how arguments are being made just for the sake of making argument and creating rah-rah in the country and not supporting matters based on its substance of logic. So all of us in this parliament, both sides, asked for central bank information. And none of that information had to do with banking. It was, and listen, the law that gives central bank its privacy and its banking authority and arm's length arrangement, it says not.
This is what we're asking for.
The minister, we are asking in this matter to disclose salary and other terms and conditions of the governor, deputy governor, officers, and so on. Organizational structure of the bank. Number of current or former officers, employees of the bank. Data, information. The number of filled or vacant positions in the structure. And such other matters relating to employment of staff. Now, the Minister of Finance and the government and the country, this is information that could be useful. It has nothing to do with the banking operations in the central bank. And if that is to remain secret, because secrecy is to be preserved, Madam Speaker, how then do you explain that the government says to you, our lifeblood is involved with respect to our business with international oil companies that function all over the world? We negotiate with them. And the commercial arrangements with those companies, for good reason, are to remain secret and confidential because an absence of confidentiality can have far-reaching commercial consequences. So we enter into memoranda of understanding with these companies to negotiate on behalf of the people of Trinidad and Tobago. While there's this demand for total transparency, even when they know the damage that will do, because many of my colleagues on the other side were in government, they had ministerial positions, including prime ministerial position. They know, and that is why they have never, while they were in government, publish the gas price in Trinidad and Tobago for the various contracts. If what they were saying now they believe, when they were in government for 5 years with all those contracts, they would at least have published one of them. But we are in government now to create public disquiet and to give the impression that we are doing something wrong and unacceptable. There's this demand for absence of confidentiality because all of a sudden there's this appetite for information ad infinitum from top to bottom. No confidentiality except central bank. And we come to this parliament, Madam Speaker, by way of ministerial statement, knowing that the public must have an adequate amount of information even when confidentiality is there. We have to walk a very thin line between informing the public and preserving our commercial confidentialities. That's what we do. And guess what? After the Minister of Energy made his statement here, Madam Speaker, by reference, by comparison, telling the country what came out of our negotiations with those oil companies, I didn't hear anybody say we have given too much information, but I've received from one of those companies a complaint that what we've said to the Parliament is in breach of the confidentiality that they expect of us. And I hope that means something to those of you, especially those of you in the opposition, who were in government and who understand what these things mean. Because I do not want to believe that you are making those demands to damage the country. Because we are all in this together. When you think that we didn't give you enough information, just what we've given have already caused disquiet on the part of those we negotiate with. We need to preserve our competitive advantage and our commercial advantages as well. That's what we need to do. And there's no question of scoring political points. There are other points to be scored. But don't try to score points at the expense of destroying the country's commerce. The commerce that gives us a living. Because if they know that they can make no arrangements with us, they wouldn't make any. Because they want us, as we are making these pressing points with them for an improved earning for Trinidad and Tobago, they said to us, we don't want to create any new template that others may want to use. And we operate all over the world. And if we make a good arrangement with you, going beyond what we normally would do, because of the circumstances in Trinidad and Tobago and your environment that we are arguing for, then it ought to be covered by the confidentiality of the clauses. Why are the people of Trinidad and Tobago prepared to shoot themselves in the foot? By demanding that the commercial confidentiality like a gas price be published. Of course, there are those who believe it must be, for reasons better known to them. But for us in the government, who know the implications of that and the benefit of not doing it, we will stand where it makes sense in protecting the interests of all the people of Trinidad and Tobago. And there's one more point I want to make, Madam Speaker, and it is this. I've heard it said, but let me just mention the pension before. Madam Speaker, this pension matter. I know for a fact that there are people in Trinidad and Tobago who believe that members of parliament, particularly ministers, are a waste of time, should not even be paid. In fact, we should pay them for the opportunity. And Madam Speaker, that is par for the course. Not only in Trinidad and Tobago, but maybe around the world. But the bottom line is this, Madam Speaker, there comes a thing that has called responsibility. You see this pension matter? It is the responsibility of a government to deal with. No opposition, except a PNM opposition, will deal with this in the way it ought to be dealt with. And you don't believe me, Madam Speaker? Let me explain to you why I said that. I went to South Africa to Nelson Mandela's funeral. And during that trip, I had the opportunity to travel in the same vehicle with the Prime Minister. I was opposition leader then. we traveled to Nelson Mandela's funeral. And we traveled in a vehicle together from our hotels to the funeral. And this matter, this particular matter of the pension issues with the judges and members of parliament was the subject of our discourse. I, as leader of the opposition then, gave, Madam Speaker, I gave the assurance then to the then Prime Minister that we will support the rectification of the issue that she raised with me. That if the government brings it to the parliament, the government can count on opposition support. And the matter was brought to the parliament. The matter was brought to the parliament as per those discussions. But of course, like it is happening now, the minute the matter came to the parliament, and that particular matter came to the parliament with more, there was much more in it. It came to the House, and the opposition supported the government's effort. There was one particular issue in there which we did not feel happy about. But I, as opposition leader, said, okay, we flag it here. We will allow it to go to the Senate and let the independent senators have a say, and we will finalize it there. So it passed the House, and it went to the Senate. When it got to the Senate, what does the record show? The then government did a complete about turn, disowned the bill that they brought to the parliament, disowned the bill that was passed by them in the majority in this House, abandoned the bill in the Senate, and accused the opposition of being greedy, and tried to pander to public sentiment that this is the opposition wanting more for themselves. Madam Speaker, I hold office in this country at the behest of the people of Trinidad and Tobago. And if the people of Trinidad and Tobago are happier having people come into public office, thieving to enrich themselves to get a good pension when they leave office, that is what the people will vote for. If, on the other hand, they are prepared to treat their office holders in such a way that you attract the best and the brightest to public office, and those who give their life in public service, like Clinton Bernard, like Marlon Gordon, like John Eckstein and others who serve this country, and at the end of their days can't pay their medical bills because their earnings from their effort in the country cannot meet their medical bills, and they must now die in indignity and wallow in penury. Madam Speaker, we beg to differ. And since it is being put out that we are particularly greedy and that the opposition don't want any part of it, not now or whenever they come into office, I have drafted an amendment, Madam Speaker, which I will attach and circulate, which will say, and I'm going to ask any member of the opposition, I have drafted the amendment, I will give it to the opposition members, and I will ask them at committee stage to put it there, saying that you will act into law, saying that you, as members of this parliament, will not accept any increase or improvement in your pension, and put it in the law. That is the only way that you wouldn't benefit. Don't get up here and say you don't want it. Don't get up and say you don't want it. I'm not talking to you, Madam Speaker. Don't get up here and play brave and say you don't want it, knowing full well that when it is passed by the government who you're beating, it passed for you too. Put a clause in there saying that you reject it by a clause in the law, and we'll pass it that way this evening. That is the only way. That is the only way you will not be beneficiaries, and I would not be surprised if some of you do that, because you have already taken care of yourself, right? So, Madam Speaker, nobody likes to hear about improvements for others, and all kinds of cases can be made. But, Madam Speaker, when it reached the point where people are so beaten down, having served the public, that a UNC minister will come to Balize House to ask for help, when it reached that point, Madam Speaker, I think it has gone very far. Madam Speaker, I had an experience once. A very senior public official in this country got into retirement and lived a long life. and got to a point where he was contemplating suicide.
Oh, Lord.
I was called by a friend of ours that this is what was happening. Fortunately, Madam Speaker, I had another friend who could have gone with me to this individual to talk him out of that situation, and my other friend who was wealthy enough to undertake to provide that gentleman with sustenance until he died. Madam Speaker, persons who give their life in the public service of Trinidad and Tobago and operate in high office ought not to see that as their future outcome. Madam Speaker, most people will tell you salaries are one thing. Salaries are one thing. But it is, especially in this time, going forward, the economy is where they are, it is a proper pension package that will attract our brightest and our best. And if the country is not prepared to attract the brightest and the best to the bench and to the parliament, then what the country is prepared to take, this government will differ. Madam Speaker, these are not simple issues, but it calls for certain principles. And the principle that we subscribe to is that we do what is right in the interests of the people of Trinidad and Tobago. I thank you, Madam Speaker.
Member for Orokuchis.
Thank you very much. Thank you. Thank you very much, Madam Speaker, for the opportunity to join this debate at a very important juncture, I believe, in the debate. Madam Speaker, a few moments ago, the head of government addressed the chamber and the nation on what is arguably one of the most controversial bills ever brought by this administration. Madam Speaker, during his address, it was noteworthy that the Prime Minister, who is authorized to speak on behalf of the government, made an amendment to an amendment, made two significant amendments to the legislation before us. I have not seen anything in writing, but we can take, I believe, at face value the proposals that will be the subject of an amendment by the member for Diego Martin West. Madam Speaker, listening to the member for Diego Martin West, a thought struck me. Had this member had one iota of information, not evidence, if this member had one clue that a company in South Trinidad was supplying water and claiming money for oil, he would have taken any one of his fingers and plugged that loophole. But, Madam Speaker, it is to the detriment of this country that the member for Diego Martin West never had a clue that they were claiming $100 million for oil and supplying
Madam Speaker,
water.
standing order 48-1, please.
And, Madam Speaker.
Use some legal.
Sure. So, Madam Speaker, I'm praising the member for Diego Martin West that if he knew of that, he would have solved that problem as well. But clearly, he had not a clue as to that massive corruption taking place. Madam Speaker, I want to respond to several issues raised by the member. But first, I want to congratulate the member for Siparia, who made a submission on the legal and constitutional issues before us, not a submission on the emotional issues before us. The Prime Minister spoke to the emotional issues. The Leader of the Opposition spoke to the legal and constitutional issues. And that is why the Leader of the Opposition was part of a legal team, Madam Speaker, that defeated the government in the Commissioner of Police order. Madam Speaker, today, the government has moved somewhat because of the last speaker. And the opposition today claim full credit and paternity and maternity, and we'll come to that later, but we claim full credit for the movement of the government in 7 days. Between 180 days to what we now calculate to be 60 days. It was 75 at the beginning of our sit-in, but I believe we have gone down now to 60 because the Prime Minister says on his hoof, on his legs, that I instruct you now, Attorney General, keep the original 30. Madam Speaker, that is the problem with lawmaking in this country. The records reflect that last week on the 7th of June, when this government came with this miscellaneous bill, the opposition went so far to call for a division, saying, no, We should not come on Monday to debate this. Let us take our time. Let us study this bill. Let us consult. Madam Speaker, when we came on Monday, I have been around this area here for 18 years. First time a bill was ever amended in such a significant way without one word in a debate. The debate did not begin and the bill was amended. It has never happened in 18 years I could recall.
And a significant change.
And significant. That is not typographical and numbering and so on. Significant. Before a word was uttered. You see, on that weekend, Madam Speaker, there was a firestorm, and I was taken aback. Sometimes we believe that, the national community would sleep away and people don't care and we talk here and nobody follow anything. But I was pleasantly taken aback, Madam Speaker, that I think 35 organizations on one weekend in 48 hours stood up to the government. The Law Association being one, Madam Speaker, and about 35 organizations. Madam Speaker, I just want to quickly read into the record a statement because it relates to the Freedom of Information Amendment. And I will not read the entire text. I'm reading from the June 14th today, the Guardian. Statement 2, this is the second statement. And they call upon the Attorney General for responding to his amendment and so on. They said this need to be suspended and further discussion and public consultation should be had. But Madam Speaker, I'm not concerned with the text of what they said because it's clear what they're trying to say. What I'm concerned is to put on record, public record, the institutions that woke up in 48 hours in this country. And I think this gives hope for our democracy. Led on Friday by the leader of the opposition and the opposition in the House. In hours later, you heard from American Chamber of Commerce, Asa Wright Nature Center, Association of Media Workers, Bankers Association, Bank and Insurance General Workers Union, CASO, Sex and Gender Justice, Caribbean Center for Human Rights, Caribbean Yard Campus, Central Pathfinders Environmental Foundation, Coalition Against Domestic Violence, Community Support Council Diego Martin, Council of Presidents of the Environment, Cropper Foundation, Environment Tobago, Environmental and Social Consultative Association, Fishermen and Friends of the Sea, Fish and Pond Farmers Association, Fixin' TNT, Joint Consultative Council for the Construction Industry, Joint Trade Union Movement, Labre General Council, Las Cuevas Eco-Friendly Association, Lloyd Best Institute of the Caribbean, Lopino Tourism Association, Maracas Valley Action Group, Media Association of Trinidad and Tobago, Matura Women's Group, National Trade Union Center, Network of NGOs for the Advancement of Women, Network of Rural Women, Producers of Trinidad and Tobago, Oilfields Workers Trade Union, they awake, Papaboa Conservation, Point-A-Pier Wildfowl Trust, Powerful Ladies of Trinidad and Tobago, Pro-C Vein Protect Children Against Violence, Abuse and Neglect and Exploitation, PTA Unit Executive, Egypt Village, Government Primary School, Region Foundation, Reset 1962, the Silver Lining Foundation, the University of the West Indies Biological Society, the Toko Foundation, the Trinidad and Tobago Publishers and Broadcasters Association, Trinidad and Tobago Transparency Institute, Wildlife and Environmental Protection of Trinidad and Tobago, Vinnie Apwan, Womantra, Working Women. Madam Speaker, that is what the Prime Minister flippantly says. Well, there's 47 organizations in the country, have 5,000. That is what the Prime Minister of the country did today. Madam Speaker, treat these organizations in that flippant and callous manner. Madam Speaker, these are critical institutions. I took note on the weekend, Madam Speaker, and I will not quote extensively, Sunday Express, June night. Withdraw Clause 7 now. And they give on the explanations. It was the Express editorial on the Sunday, which had to be written on the Saturday. The bill was made public on Friday. Jump into action. Madam Speaker, the drafter and presenter of this Freedom of Information Bill, Ramesh Lawrence Maharaj, threatened to take action in the courthouse and on the street and anywhere else, I think by the weekend as well. Other voices, the Southern Assembly of Lawyers issued a statement. And the Southern Assembly of Lawyers issued an interesting statement. Mr. Michael Ruplal indicated that in the modern age, Madam Speaker, with digital technology, you should be given information faster. Because we are not in the age We are not in the age when my friend from Arima was wearing short pants in primary school. We are in the age now of digital technology. So you should be able to get information faster than you were able to get in colonial time. So you should come to the house and say, instead of 30 days, we reduce that to 20 days. That is what you should be doing. Madam Speaker, so I want to put on record those matters. During the week now, Madam Speaker, quickly, you heard from all type of people in the media and so on. Mr. Terence Farrell, I think he was formerly at the Central Bank. You heard from one Uric Bob, Madam Speaker. Personally, I did not even know that Mr. Bob was still around. I'm happy that he's up and about. And he wrote as well concerns about the bill, Madam Speaker. Winston Dukaran, of course, other persons, 47 organizations plus other persons. Madam Speaker, if we had deferred this bill by 1 week, we might have heard from Victor Bruce on this matter. Madam Speaker, but the government is along their merry way. In their mind, they're in a frolic. We have heard those organizations. Let's move on. Madam Speaker, you heard from the government today, and what is the central issue that the government is raising? What really is the central issue? The central issue is that we want to save costs. We want to save MONEY, because they have some smart man out there. They're using what they call loopholes in the law, and the Attorney General is very clear. He said nobody breaking the law, you know. But they're using the law, and they claim that they're making money. So the role of this government is to stop that from happening. Not the AV drilling, not anything else. Let's stop that. You see, Madam Speaker, this bill is not about saving money. It is about saving face. It is not about saving money. It is about saving face. When the Attorney General rattled out the statistics over 2008, 9, 2016, there are certain things that jump out at you without even studying it. Why it is when the People's Partnership UNC is in power, you have less freedom of information requests. Why? Because the lawyers are in the government, and the PNM lawyers apparently are incompetent to raise freedom of information. So PNM lawyers don't know about this. They don't serve their clients in judicial review matters. Madam Speaker, they call the name of Anand Ramlogan and Ramdeen, and I think they are not members of the House. The Attorney General is correct if he wants to call their name. There's a fellow by the name of Michael Kwamina. Anytime I see him in court, I just follow him. So one day he said, why are you following me? I said, any courthouse you go in, I sure I have a matter there. Because he represents every government enterprise. He's the Prime Minister's lawyer. I will not go to say he's a PNM lawyer because, you know, the Attorney General will use that type of language. But I told Mr. Kwamina, I don't know the courthouse set up too good, but anywhere you go in, I go in. I'm almost certain that you are against me. So they do it, but why in opposition? The PNM lawyers didn't use the freedom of information to defend the interests of people, seek information. You know why? It is not because they're incompetent. Maybe it is so, I don't know. I can't say that. It is because when we were in office, we never had that record of refusing freedom of information. Madam Speaker, in the 5 years I served as a minister in a significant ministry, big, I cannot remember one occasion, I can't, maybe you could remind me, when we turned down a request for freedom of information. I'll go further to tell you when requests came to us, Madam Speaker, and we considered it. I would tell the relevant legal officer, I would say, tell me something, what do we lose by giving the people the information? Because if they go to court, they will get it in any case. And it will become a scandal when they win a court battle. So give them the information. Madam Speaker, if they give the information to Devan Maharaj, Ravi Maharaj, and any other Maharaj, you save money. You save money. And give the information. Madam Speaker, the Prime Minister again today, you know, everything about this Prime Minister is something else, you know. You know, talking about speaking in a car, I spoke about my ministry. Everything speaking in a car with the Prime Minister during the time and so on. Madam Speaker, we have a beautiful division of labor on this side of the border. I will speak on this freedom of information matter. My colleagues will deal in detail with pensions and central bank and so on. But I just want to remind the member for Diego Martin West that the freedom of information has a little gestation period. Madam Speaker, I have the records here. And you know what is fascinating, Madam Speaker? When this bill was introduced in 1999, it was passed in 1999. Madam Speaker, I read the excerpts from the Hansard. Mr. Ramesh Lawrence Maharaj, of course, piloted. The member for Siparia, Kamla Persad-Bissessar, spoke on this day in support of the Freedom for Information legislation. Madam Speaker, what is fascinating, and I don't want to read it, spend my time reading Hansard extensively, but when the member for Degomartin Northeast had to talk on freedom of information, you know what was his position? This is abominable. How can you do this? Today the UNC is here to legislate secrecy. They are here, look at the exemptions. They are here to legislate secrecy. And this is abominable. Madam Speaker, I have a next classic for you. If you think that was bad enough. The member for Aruka Maloney, we have the answer here, we're going to quote in extensive detail, declared to the top of her breath when she was contributing on freedom of information. She said, imagine they're given only 30 days. They should give the information in a quicker time. So much, 30 days, that is too long. State enterprise will distort information, will hide information. The member for Aruka Maloney concern on that day was that 30 days was too long to give information. Oh, what a tangled web we weave when first we practice to deceive. So the member for Northwest said it was an abomination. The member for Aruka Maloney, she was very concerned that 30 days was too long. Look where they are today. They started with 180 days, Madam Speaker, and that was in their mind. You know, the days keep changing as if you shuffling cards and you get a 9 or you get a 7 or you get a 3. The next speaker talking might change it again. Because it is not something that is thought out. The Prime Minister said a few moments ago, he said when the opposition leader wanted to deal with this matter of pensions, she consulted him. Albeit I believe he should not be divulging in that way private discussions, but she consulted him. I want to ask if he consulted her in bringing this matter. Did he consult the opposition? And when you determine 180 days, what told you 180 days, 90 and 90? What informed that? What? So when you jump down to 75 days, what told you that, listen, we don't really need day 76 to day 180? What told you that? And when you jump down to 60 days, what told you that you don't need 61 to 75? That is policy by VAPS. That is policy by VAPS. Madam Speaker, I'm going to deal with that matter of monies and so on in a little while, because the Attorney General on Sunday, June 19th in the Daily Express had the story, Alwari, a money-saving move, Madam Speaker. And so that was the issue. But you are not going to save money by just coming here, standing up, gallerying, and then moving from 180 to 75 to 60. Later tonight, 50. Later this evening, 42. It is not like that. This is not, it's not lotto or something. You're just grabbing numbers and say we could win with something. Madam Speaker, this is a serious matter of freedom of information. And when the opposition leader spoke earlier, Madam Speaker, I was amazed to hear the research that Bangladesh, with good respect to all the Bangladeshi people, they're playing good cricket, Pakistan and others, they have 10 days and 20 days to furnish information. Could you imagine that? Yeah. And Trinidad and Tobago want 180 days as proposed. Madam Speaker, what is this happening in the world? What is the world coming to? Madam Speaker, just briefly in passing, I want to get quickly to my freedom of information matters. The central bank, I took note of the statement of the Prime Minister today, Madam Speaker. In one breath, he would ask us to keep secret and the sanctity and integrity of his energy-related deals, his energy-related agreements. Huh? Be patient, and we have to keep that secret. Don't undermine the state. And in the next breath, you stifle information to the population of Trinidad and Tobago. The other thing I want the Prime Minister to record, when it is that the Freedom of Information Act was passed, Madam Speaker, the central bank was under the Freedom of Information Act. Yes. Who removed the central bank? PNM. It was the PNM that removed the central bank. And Madam Speaker, and removed 10 other enterprises. And 10 other enterprises. Madam Speaker, the opposition then wanted to find out about a director, his travel, his fees. When we sought to find out that the PNM government, including the member for San Fernando West, including the Degomartin Northeast, I think Aruka Maloney was banished at that time to Canada. You were in Canada, banished at the time because the former member for San Fernando East had some wisdom in that matter. Madam, no, you have to wait for the Martin West to return. Madam Speaker, the government of the day, Madam Speaker, the government of the day came with a bill here and they moved the central bank from under freedom of information, put it as an exempted authority because they did not want to release information on a director. Today they are searching for information, among other things, on former employees. Record. So the Prime Minister said, what is wrong? We want to know about organizational structure. And the central, sorry, not that. Does not the central bank produce an annual report that speaks to their structure, their organization, a number of employees, this and that? They have an annual report that gives you some basic information on those matters. But you see, Madam Speaker, maybe somebody is planning a defense in the courthouse and they need to get information to put in the defense. That is what is happening here today. They want information to put in a defense. That is why they have to go back. Madam Speaker, so we go on to 60 days because we want to plug this loophole. You see, Madam Speaker, the Attorney General spoke today and dealt with several matters, and at the heart of the Attorney General's contribution is this issue of cost and so on. The Attorney General admits freely, without anyone pushing him, that there's a process that involves practice directions, pre-action protocol letters, and so on, that goes to the Solicitor General. And as opposition leader said, the Attorney General boasted before a week, looks at all these files and supervise and so on. So you must know what is being asked for and what is not being asked for. You don't need this type of intervention. Now, quickly, Madam Speaker, we are in a World Cup time, as you may well know. What is happening in this bill is the Attorney General wants to become a third umpire while he's a member of the team on the field. He wants to be the third umpire, but he's a member of the team on the field. You cannot have a third umpire who's a member of the team. In our political structure, unlike, I believe, even the United Kingdom, the Attorney General is a politician. In fact, the Attorney General of this country has been the public relations officer of the government party. And nothing is wrong with that. Nothing is wrong with that by itself. But the Attorney General is a politician. You cannot be the third umpire to say, come to me, I will give the green light or the red light, or keep the red light rather, and give you a green light. Because you are a politician. You are in a political setup. We're into election run now, Madam Speaker. State enterprises will lock down on freedom of information and say, see me? I'm not giving nothing. Go by the Attorney General and let him overrule us. So we were going to 180 days. Well, it came down, I think, by the amendment, the verbal amendment, to 60 days now. Why just don't you keep what you have in the law today at 30 days? And the process is clear. If a state enterprise says no, letters, pre-action protocol letters will be copied to the Solicitor General. Or insist, but it is a practice as well, to copy to the Attorney General. You will know. And just tell the people, because it is a few, it is not a lot. The Attorney General admitted that we're really not dealing with a lot of matters. Less than 1%. I was shocked when the Attorney General was using percentages and were calling 95%, 96%. I think the lowest was 82%. So it is a small fraction you are dealing with of these matters. You don't have to uproot the Constitution to get knowledge of that and deal with it. But you see, Madam Speaker, the whole process of judicial review also takes time. Madam Speaker, on Friday I had an interesting experience, and I could tell you it's not before the court. In one of the several matters I'm involved in the courthouse, driven by this government and their allies, of course, I sought information, Madam Speaker, from the Housing Development Authority. And we applied for the information. Madam Speaker, no information was forthcoming in the time. So good. We went through the process, wrote the letters. Court fixed an appointment for Friday morning, Madam Speaker. I informed the whip that I'll be there. Maybe I will spend more time. I'll be late here. 1 hour before, I got message. HDC changed their mind. They said, well, they'll give me the information, Madam Speaker. Now, I still have to pay lawyers because the lawyers prepared their case, so I still have to pay. Now, had this been done in a process where the HDC would look at it, Madam Speaker, determine immediately within their 30 days, look, we can give the information. Just give me the information and save me money, save the state money. I am almost certain that the HDC has to pay lawyers to come to court on Friday because it was 1 hour before they changed their mind. So the HDC has to take taxpayers' money and pay lawyers for what would have been a hearing on Friday last. And Madam Speaker, today they said they are about saving money, Madam Speaker. We came to the Parliament, now the Prime Minister talked bold today about saving money, and he has a job to protect the taxpayers' dollars. Madam Speaker, we came to this House. We asked in a question for written answer the amount of money being spent on legal and professional fees for HDC matters and for EMBDC matters. We asked. There was a reply in writing. It is on the record. They said, no, we can't give you that, because if we give you that, it would jeopardize the case. So the taxpayer knowing how much money they are paying in legal fees would jeopardize the case. That is the government that said that. The Prime Minister, they told us he wants to save money. But a few things in the world you are sure of, we will find out. If not next week, next month, next year, we will find out. You can't hide. When you're in government, you think you could hide something. Eventually, the opposition will find out, regardless of which opposition. So, Madam Speaker, I put that on record. Madam Speaker, I just want to correct the record of a few things mentioned earlier today. You see, Madam Speaker, the process in this matter, I just want to touch this again. The Attorney General raised the Petrotrin matter and spoke to this issue of the Ravi Balgobin Maharaj versus Petrotrin, which is called the Malcolm Jones case. And Madam Speaker, for the record, look at the chain of events. On 11 March 2016, the application submitted to Petrotrin for Freedom of Information request. 11th March. 22nd April 2016. How much days is that now? 22nd April to that is about 1 month. Petrotrin refuses to provide witness statements. 11th May, Madam Speaker, another 2.5 weeks. The claimant asked whether edited versions of the witness statement could be given. So the claimant said, I don't want the whole thing now. Give me edited version. Madam Speaker, on July 4th, we go from May to July. Look at time going, huh? Pre-action letter sent to Petrotrin, Madam Speaker. Madam Speaker, on the 29th of July 2016, end of July, Petrotrin seeks 1 month extension to reply to pre-action letter, which was granted. Madam Speaker, 29th August, look where we reached now. We started, Madam Speaker, I just want to remind you, we started this game 11th March. We reached 29th August. Petrotrin responds to pre-action letter confirming that it was not prepared to disclose statements. 24th October 2016, application for leave for judicial review filed. So between 11th March to 24th October, 7 months. This is before both Petrotrin, and I will get to where it reached to. The Attorney General claimed about not being in the loop so that he would have advised Petrotrin and prevented the case from going to the Privy Council. I am not sure the Attorney General would have had full command of the facts. If he knew the facts, he would not say that. In accordance with pre-action protocol practice, the Solicitor General was in fact copied on the pre-action correspondence. The fact was expressly stated in Ravi Maharaj's affidavit and copies of letter, which was served on the Solicitor General with the endorsement of the relevant officer in the Ministry of the Attorney General, Jonathan Henley. As proof that it was served on the Attorney General, it was exhibited in court. So the Attorney General had knowledge of this. Madam Speaker, the whole purpose of the mandatory requirement of the Solicitor General to be served with pre-action letters against the state or any state agency is to ensure that the Attorney General is aware of the proposed JR proceedings. This applies in any case where declaratory relief in judicial review is sought. Madam Speaker, the Attorney General had time to settle this matter at the pre-action stage when he received the pre-action protocol letters. Why didn't they settle them at the case management stage when legal costs would have been relatively small, instead allowing them to go to trial? Madam Speaker, this is not about saving money. It's about saving face. Why did the Attorney General not tell us any of this knowledge of his role and involvement? The Attorney General, the records could show, was in the loop. Madam Speaker, there was a need for the Attorney General to intervene to save money even then, when Jonathan Henley, whoever that is, received on behalf of the Attorney General, was served with the documents, Madam Speaker. Madam Speaker, The witness statements are now in the public domain, Madam Speaker. They were presented after going to the Privy Council, Madam Speaker. Those witness statements speak to the advice given by one Vincent Nelson, upon which the government depended to withdraw a matter against a multi-billion-dollar case against Malcolm Jones. Madam Speaker, to this day, only the Charmaine Baptiste and the Anthony Chantak statements have been given, not the statements of Kelvin Singh and Imtiaz Ali, Madam Speaker. Okay, I asked for that. Give me. I asked for it. I wish to read, Madam Speaker, when you read those statements, I may not have time to read in detail those statements, but it is clear, crystal clear, clear as daylight, that those statements in no way could have caused Vincent Nelson to change his mind. Madam Speaker, the Attorney General cited a case of Daryl Hiralal and the Ministry of Finance. What is on record in this matter, Madam Speaker? Information was sought on the legal advice to fire the former governor of the central bank, Roodal Moonilal. These cases were filed because, once again, the government refused to provide information. To make matters worse, Madam Speaker, they failed to obey the court order for disclosure, and hence a second claim. You see, the claims pile on when first you fail to give information. There's a court order to give information, and you do not abide by the court order, there's another claim. And that's where the money keeps piling up. But if you just give I don't want to use any word badly here. If you just give the information, you will not have that problem, Madam Speaker. Why you didn't simply use the Minister of Finance to give the information? The former governor of the central bank is now asking the minister from Diego Martin Northeast about more information.
Thank you. Member for Rupuchis, your original speaking time is now spent. You're entitled to 15 more minutes to wrap up your presentation. You may proceed.
Thank you very much, Madam Speaker. Madam Speaker, the issues before us include and involve this matter of the cases and the money and so on. Now, you hear the Prime Minister, you would believe that, you know, this freedom of information business is bankrupting the Treasury. I mean, I don't know. The Treasury has collapsed because of freedom of information. But why must we go to law lords in London to get information about a witness statement in Pointe-à-Pierre? That is embarrassing, I believe, Madam Speaker. Madam Speaker, in the matter, I am advised that no cost has been paid so far in the matter of Vijay Singh versus the Ombudsman. There have been no requests for payments of $1.7 million, Madam Speaker, and I ask the government to bring evidence of that request. And request from who? The legal costs have not been assessed by the court, and the court will assess costs. You know, there's another interesting point, is that when the lawyers of the state finish their work, they bill the state. So the public officers, the Prime Minister is talking about public officers, would give a sign-off of the state lawyers. The court assess the cost that you have to pay to give to the lawyers who won the case, so to speak, Madam Speaker. So that they are jumbling everything here between state lawyers and lawyers who are for the claimants, generally. Madam Speaker, there have been no costs assessed in Vijay Singh and the Ombudsman. The Ombudsman was represented by lawyers, including eminent senior counsel and junior counsel, Mr. Elton Prescott and Mr. Ricky Harananan. But we don't want to know how much they get paid. Huh? I mean, nobody interested in that. They're interested in Ramdeen and Ram Logan. Madam Speaker, and I take umbrage to this notion of UNC lawyers. Let me say, I take umbrage one time to that. People are professionals. In this country, we are still free to vote for a party of our choice. We are still free, I believe, to support a party of our choice. And people ought not to be branded, to be demonized, to be criminalized as UNC lawyers. I've never referred to anybody as a PNM lawyer, although if there's a PNM case, you could close your eye and think who will be there. But I don't do that because they are professionals. It's a profession and they have clients. They have a right and a duty to represent their clients, Madam Speaker. So the political label is something I take umbrage with. Madam Speaker, in the Vijay Singh versus Public Service Commission matter, another case raised here. Madam Speaker, I am informed that Mr. Singh was awarded a paltry sum of $7,500 in legal costs. Imagine this, legal costs awarded $7,500. The lawyers for the Attorney General's ministry applied to have that order for costs set aside. Huh? It was set aside. This he defended all the way to the Privy Council, where he eventually lost. So you see what happened there? $7,000 for $7,500. They applied to set that aside because they said $7,500 was going to break the Treasury. And they won, I think. The Attorney General is saying they won that. They got it set aside. So, man said, well, $7,500 you're trying to get from me. They go all the way to the Privy Council where the guy won. The taxpayer end up paying much more than $7,500. Had you simply paid the $7,500, you would have been spared the thousands of dollars that you would get from the Privy Council. Madam Speaker, no UNC lawyer milking no system. I think they are milking incompetence, inefficiency, and in some cases they are milking discrimination and victimization. You see, Madam Speaker, there are two matters before us, Madam Speaker. There are two hot matters, and I'll get the data in a minute. Madam Speaker, the Prime Minister came out, and indicated in the national community, I've instructed them, to give information. Don't let these lawyers go to court and rob the Treasury of milking and what? An industry of exploitation the Prime Minister spoke to. Madam Speaker, I have a letter in my hand dated March 19th from the office of the Prime Minister. That is the office that Diego Martin West temporarily occupied. March 19th from the office of the Prime Minister to a lawyer at Freedom Law Chambers. Well, they will get frightened with this one now. Dear Mr. Whatever the lawyer is, I refer to your letter dated November 27, 2018 and January 18, 2019, respectively. On the above subject, the subject is request for access to official documents on behalf of Devat Maharaj pursuant to Freedom of Information Act and so on. And I request to tell you as follows, a copy of the report given to the Honorable Prime Minister from 3 members of an investigating committee to investigate the situation involving former Minister of Sports and allegations of misconduct. A copy of the settlement agreement between the Ministry of Sport and one Carey and Moray. Please be informed that the report by the investigating committee on the person contains information that was obtained in confidence, and as such it is exempt under the Freedom of Information. So the Prime Minister is telling everybody, give the information quick, save money. And the office of the Prime Minister telling you, look, that is exempt from information now. So you can't get it. You can't get it. The disclosure would be contrary to public interest. So, Madam Speaker, they're going to court again. They're going to pay money again. Mr. Attorney General, with or without any power that could be conferred on you today, instruct the office of the Prime Minister forthwith to supply the information. Madam Speaker, so the Prime Minister talking loud up and down the country, lawyers getting money from this, they have a loophole. And look, March 19, just the other day, they're denying information using Freedom of Information Act. Madam Speaker, that is not all. They have a next one. Madam Speaker, Madam Speaker, while they were drafting this bill, somebody going to court again. While they're drafting this bill, Madam Speaker, they're going to court again. And hear this one. Devan Maharaj gone to court while they were drafting the bill. And he asked for information on the Dragon deal to find out, money spent, the nature of agreements between the government of Trinidad and Tobago, etc., to get information, Madam Speaker, on the Dragon deal. It was against the National Gas Company, claim number CV 2019. Well, they will get a number soon. And Madam Speaker, this is pursuant to the documents pursuant to that initiative and that claim. But what I want to read again, the court ordered, Madam Speaker, on last Friday 7th. Imagine when you put this thing in to stop information, the court ordered a declaration that the decision of the proposed respondent defendant to refuse or deny application is illegal, irrational, unfair, and amongst a breach of the provisions of the Freedom of Information Act. So, Madam Speaker, yet again on the Friday they laid this bill, the NGC lost a matter in court, Madam Speaker, where someone asked for information on Dragon deal. They wanted to leave to apply for judicial review and so on, Madam Speaker. They went and they had an order. Madam Speaker, the problem with the government, Madam Speaker, is that you are trying to smother information. If a directive goes out through the cabinet to the permanent secretaries, indicating that freedom of information is a very, very serious matter, the government's policy commitment to transparency, accountability, and scrutiny by any and everyone, they will understand their role and function. And they will not have to take 30 days or 90 days or 180 days. There will be a culture of freedom. A culture of freedom. You see, Madam Speaker, today, we did not have to meet here like this. We did not have to have a situation where the Prime Minister comes and, on the hoof, so to speak, indicate that we move in. They wanted to reduce, we reduce it. So Madam Speaker, if this evening the Deputy Prime Minister from Port of Spain not speak, that 60 days could well go down to 40, Yeah. That is how you are attempting to make policy. Madam Speaker, the freedom of information in this country has a long legacy, Madam Speaker. It is something that the people fought for. They fought for. 1999. From 1999. It was something that when we sought, the very government of the PNM amended it several times to deny information. Their history has been in exempting, denying information, not providing information. The attempt now to raise the number of days is a deliberate attempt to frustrate and undermine that process. Madam Speaker, the Attorney General could go further. Red flag the 2 lawyers, because I think there's only 2 lawyers in the world they bothered about. Only 2. Why don't you raise a red, I'm going to say John Lee, raise a red flag and tell every government ministry, anytime you hear from Freedom House, Freedom Law Chambers, Ramdi and Ramlogan, send it at once. Don't wait. And forget everything else. Forget everything else. Because 2 lawyers giving them sleepless nights. 2 lawyers, Madam Speaker. And 2 lawyers have us here today to violate the Constitution that they are trying to do. Madam Speaker, you cannot undermine the Constitution because you cannot deal in the courthouse with 2 attorneys at law. Madam Speaker, when I was faced with a couple small hiccups and so on in my normal course of public conduct, Madam Speaker, I don't want to bring any extraneous matters here, but there are times when public authorities sought to take action against me. Madam Speaker, these are the same 2 lawyers who went to court and have me standing up here talking to you.
They're brilliant.
Madam Speaker.
They're brilliant.
Madam Speaker, I just want to return to this matter to put 1 or 2 issues on the agenda. I just want to ask the Attorney General, could we expect more amendments to now take public authorities, certain public authorities, outside of the purview of your intended legislation, which we don't support? But could you indicate if any public authorities, for example, that are authorities that are independent under the Constitution and the law will now be exempt, to use that term, from sending their red card to the Attorney General to look for a green card, certain public institutions? My time is very limited. Madam Speaker, and I'm speaking here because you see in this list, you have the service commissions, you have the Industrial Court, the Equal Opportunity Commission, you have the Tax Appeal Board, you have in Ministry of looking for it in law and order as well, Madam Speaker. You have the DPP office, you have the Parliament, Madam Speaker. You have institutions that are protected by the Constitution. Now, when these institutions send their report to the Attorney General under this proposed law, the Attorney General is entitled to tell the DPP or the Parliament, could you send the files for me? Before I can make a determination on whether to overrule it, before I can make a decision on whether or not to overrule your decision, I have to have sight of the facts because it must be a reasonable decision, Madam Speaker. You know the Attorney General now, and I cast no aspersions on the current Attorney General. The Attorney General will now have access to sensitive information from constitutionally independent organizations. And that, Madam Speaker, is not a power we ought to give any Attorney General. None, Madam Speaker. The law as it stands provide for a process. All the Attorney General has to do is tighten up in his department that little pipeline with the Solicitor General so that you monitor what is happening maybe on a weekly basis with the Solicitor General, what claims are made, and you deal with it that way, Madam Speaker. There is no need for an Attorney General to intervene in this matter. Because, you know, there's a paradox emerging here. The government tells us that the government did not close down Petrotrin. Was Petrotrin closed down Petrotrin? But the government is telling us now, we want information from everybody, Madam Speaker. We want information from everybody. But you allowed Petrotrin to close down themselves, according to you. But today you want the information from everybody. Madam Speaker, these things have serious consequences, I believe, for the law. I believe, Madam Speaker, that I support the 47 organizations out there and individuals that this is a dubious piece of legislation. Madam Speaker, we ought, Madam Speaker, I support one P.S. Robinson, whoever he is. I'm told he's related to a minister, but he also came out. Madam Speaker, the member for Aruka Maloney, take ownership of the person, but not the comments. P.S. Robinson said, I cannot in all conscience support the proposed amendments to Clause 7, Madam Speaker. It is an affront to the principles of democracy and careful protections afforded to citizens. Madam Speaker, what blood is this that can say this from one member of the family and the next member of the family voting to shut down freedom of information? Madam Speaker, the matter of freedom of information ought to be withdrawn. I will leave the issues of pension, I will leave the issues of central bank to other colleagues, but the freedom of information by itself, if it wasn't terrible by itself, ought to be removed completely. And the other matter I support is that there was no need for this type of miscellaneous bill. If you want to deal with tax amnesty, deal with that and matters related to that. Miscellaneous bills don't mean that you could take a bill on metrology and put it unconnected to customs amendment and put it unconnected to prison reform. Miscellaneous is that miscellaneous always meant that you take bills that deal with the same objective and you bring that together as a miscellaneous bill because it promotes the same objective. And Madam Speaker, so this miscellaneous bill is historic in a sense because it cannot be that it deals with 9 different unrelated, unconnected matter. And coming as it did as a thief in the day, it is further evidence, Madam Speaker, that the government did not think out this matter and they ought properly to go, Madam Speaker, think again and withdraw completely. Madam Speaker, I just thank you.
Member for Laventille West.
Thank you very much, Madam Speaker. Madam Speaker, the policy of the government is what it is. It has not changed. The policy of the government is reflected in the law, the Freedom of Information Act, which is on the books, and we found it necessary to make adjustments as we do to all laws. I heard the member for Oropuch East telling us very confidently that all the AG has to do is to follow the law, but we make amendments to the laws all of the time. If you identify lacunae or loopholes, it is incumbent on the government to solve that problem by fixing it. Madam Speaker, he alluded to this issue that the AG dealt with when he made his submissions here. In Part 56 of the Civil Proceedings Rules, the case of Moonilal Ramsingh and Eric James was dealt with in respect of the rules in that matter. And the court said that in those circumstances, the Attorney General, this is the court speaking, the Attorney General should be informed as to the action for judicial review at the time that it is it is launched against the government, where he is always a party, the office of the Attorney General. All that is happening here is that the Attorney General is proposing, we are proposing, that he be informed before. So that if the authority decides that it will grant the information under the existing law, and we propose in the circumstances to leave it like that, they will go ahead and do it. There's no intervention for the AG. If, on the other hand, they decide to refuse, then, as the court said in Moonilal Ramsingh and Eric James, when the party takes the action to file an action for judicial review against the decision to refuse, the AG is, we are proposing, Madam Speaker, that he be informed earlier, so that the agency informs the Attorney General at the same time they are informing the person who requested the information. And the Attorney General at that stage, before an action starts, has an opportunity to cast the eye of the government's legal advisor upon it, because after all, it is the government that takes the flak. It is the government that gets the criticism, and it is the taxpayer who pays money, whether it's a big sum or a large sum. And that is all we are saying, and that policy has not changed. All that is happening here is that the process that we want to implement in these amendments will strengthen, in our view, that process. Because if the agency, as happened in the Petrotrin matter, says no, then the Attorney General, and on the facts of this matter, had the Attorney General been informed before, he would have advised them, casting his legal eye as the government's legal advisor, with more legal resources available to him, that it was not the best way forward, with reasons. And then they would have rethought the position, or at least take into account what the Attorney General was saying. If he agreed with them, it strengthened their decision, and therefore they go to court if the person opted for court on the basis of knowledge of a second opinion from the Office of the Attorney General. And of course, if he advises otherwise, we save the action in the first place, as the court is recommending. So to my mind, what that does is to strengthen the process rather than take away from it. That's the argument. I heard the member for Oropouche East talking about thief in the day, something that he said last Friday when we all in this parliament got notice of the government's intention to discuss this omnibus, miscellaneous bill that is before us today. He immediately got up and called it, we're trying to do it like a thief in the day. And I saw him in this chamber. He went to two members of the media, senior members of the media. And from the stories written the following day, it was clear to me they were misled. I took the trouble to read it carefully. And I saw where I mean, he misled them. The same thing he was saying here, within my earshot, apparently he went and told them that the measures in respect of the pension arrangements was only for the government. And one of them wrote that. So that was proof to me that a lot of people, and he outlined a long list of people who jumped in protest against that measure. It was proof enough to me that there are people who will jump and shout without reading one line of the bill. In Trinidad and Tobago, nobody could quarrel with that. That is possible here. And then when the facts come, they say, oh my God, we did not know that. You know how many people believe that there are 50 and 60 and 70,000 Venezuelans? And how many were coming by boatloads for the last few days? Today, when the facts were put of 13,000 as at yesterday, I'm watching on social media now, disquiet, all the old talk done, except from Kia, who you might be surprised to see turn up here as a UNC senator anytime. But that's how they just get it in the UNC, you know. But, Madam Speaker, that is not the issue for me today. That's not the issue. Madam, 48-1, you all are so ashamed of Kia. Let me hear what the motion is, 48-1. Thank you very much. Don't be ashamed. She's paid and out front, or he, or... I'm not sure. Madam Speaker, so this government and this issue, let me cause the public and my colleagues, if it escaped them, to understand. The measure that we came here today in respect of the freedom of information, as far as we are concerned, is part of our fight against corruption. And corruption, by our definition, means using your office for personal gain, twisting the system. Yeah? We are fighting that. Singapore had issues with that. I hear my friend from Naparima always talking about Singapore. And he's now whispering 23 million. I need not pay attention to him. But it's a talk that they've been carrying on. And I want them to understand, Madam Speaker.
Distracted.
I appreciate that, Madam Speaker.
Please don't be distracted.
I'm not being distracted. But if I spent money, anyway, I'll come to that another time. 23 million what? Madam Speaker, Singapore had issues. All countries of the world where it's populated with human beings. Malaysia, the United Kingdom, Australia. As an experienced parliamentarian, speaking with parliamentarians from all over the Commonwealth, the issue of compensation for parliamentarians and government ministers is not new. In 2014, the United National Congress and government had to deal with recommendations of the Salary Reviews Commission and implemented their recommendations. Prior to that, in 2008 or so, Mr. Manning got a report from the Salary Reviews Commission, which ought to be reviewing our salaries and conditions of work every 3 years. And he refused in public outcry to implement it. Refused. In 2014, when a report came, the UNC implemented it with one exception. That was where some person recommended, Madam Speaker, that the tax allowances that we enjoy on the purchase of motor vehicles be taken away from us. That came in a report. All of us balked at it. And the UNC agreed with that, balked too, and took it out, because at the end of the day, it is only recommendations. And the cabinet, the government will implement it as is or could make changes. Madam Speaker, we are dealing with corruption. Singapore took the position as a matter of policy. You pay your public administrators, including elected officials, ministers, well, and you hold them to account for corrupt deals and actions. The same with the UK. When you compare our income, and I'm not fighting for anything, I'm speaking truth here today, with that of the UK and the United States and other countries, and I'm sure they don't have to deal with some of the issues we have to deal with in this third world space, where it's very personal, direct, every single day. If any member of parliament walks the streets each day with $10,000, it would be easy to give it away. You get requests for 12 and 15 in totality for help, genuine help sometimes. Sometimes to buy a beer, to buy a drink, and stupidity like that. But in many, many, many cases, I, as an experienced member of parliament, encounter situations where the call is real. For groceries, for medical bills, for all kinds of things. And you could easily say, go to social development. They have food card and all that. That could take a month, 6 weeks. In the meantime, there are some realities in front of you, and every single person here could attest to that. Everyone. So our experience is a little different. So, Madam Speaker, they say if you pay peanuts, you won't attract anything else but monkeys. Fortunately for this country, the PNM have been honest monkeys. In that metaphor, not everyone could boast of that. Because we came here today to propose a formula not to improve salaries.
Stop it.
Not be describing his colleagues as monkeys.
I
Just withdraw it.
That's nonsense.
Please continue.
Nonsense. Rubbish. Madam Speaker, we came here today not to deal with salaries. It was said earlier here today. On Wednesday, June the 12th, 2019, just permit me, in a Guardian story written by Kevin Felmin, it says, and I begin, up, and it has not been denied. I read the papers subsequently very keenly for denials. Opposition leader Kamla Persad-Bissessar is urging the public to keep an eye on government's plan to increase the salaries. So the member for Oropouche East wasn't in bad. He wasn't alone when he went to the media and gave them a very twisted version of what is before us today. The member for Siparia speaking a long time after we presented it here, hours after, because she was speaking on a platform the Friday night, and she spoke to the media after that. She said that we are dealing with salaries. We're not dealing with salaries. We propose today an adjustment in the computation of pensions. That's what we propose. Madam Speaker, there's another model other than the Singapore model that I just described, and the Malaysian, and the UK, and the Canadian, and the United States, who would all laugh at us. I spoke to a retired PNM minister who spent 12 years in the government from his report to me, and like everyone else, I'll call no name. And Madam Speaker, I spoke to several of them, including UNC former ministers. One UNC minister who served 5 terms. In one case, the pension that former member now gets works out to be about $500 US a month. That's about 3,000 Trinidad and Tobago dollars. If a US congressman hears that, he would laugh at us in Trinidad and Tobago. George Michael Chambers came into politics as a humble man, and from the reports that I know, died a humble man. No great material achievements. Served this country. Dr. Williams died. I recall, I was a police officer at the time. He left an estate of $31,000 in 1981 when he died. After building this country, laying the foundations for everything that we have today, and complain bitterly about everything we complain about. In a land that provides medical care and education and social benefits and housing and books and lunches and all kinds of things to our citizens, things that don't happen anywhere else. Yesterday, I attended a swearing-in ceremony for medical doctors in Barbados and spoke to some young students there. And what we could boast of with Gate here, many a youngster who come out of the University of the West Indies and other parts leave university with hundreds of thousands of dollars in loans to pay, but yet we complain. And we heard already, but it is worth repeating. There's another formula. You could pay yourself up front. We know of a former minister who came out of a job in a state enterprise, state-run institution, with $13 million. You know that. And then we have, as a fact, Madam Speaker, persons who held public office in this country now before the court and being asked to account for using the very public money to give more than is due to the service providers and getting kickbacks. That's a fact. No name. That's another formula, but that's not what we subscribe to. And if you want more proof before I move on, because I want to talk about freedom of information, a friend of theirs, my friends on the other side, pointed out to me that there's a contractor who became big and rich and famous, the biggest in 5 years, who when the 5-year term started in the last administration was only known for having a number of short-term guest houses. Very short-term, I mean.
Short-term stay. Short stay.
Not even a staycation, a pass-through station. But ended up after 5 years running away from Trinidad and Tobago with millions and millions of dollars on account. And you don't let me call no name, you know, because you all know him well. The member for Siparia know better. Because back in 2010, Madam Speaker, speaking right here as an opposition member in this House, I had to deal with a $56 million contract award, not to build a school or to build a community center or to build a health center, but to repair the Siparia market. $56 million. That was the first. Culminated with a $1 billion contract on the Beetham Highway and then disappear. That's the record of our country.
Madam Speaker,
So there's another
48-1,
formula.
please. 48-1.
I'm gone. You could stay right there. Madam Speaker, as long as we continue our struggle and could not be accused of those formulas and that model, I am proud and stand here in support of the measures before us today. Madam Speaker, I want to move, and I have noticed in passing and in closing on that not one of the speakers on the other side touched this matter today, notwithstanding what they've been saying outside of the Parliament. You see what I'm talking about, the duplicity? They've been on platforms, they've been on social media, they've been to the media, traditional media, talking about it. But today, you will notice, Madam Speaker, not one in criticism of it. They want to run with the hounds and run with the hare as well. 1 foot in, 1 foot out, like a Callaloo Christian. But that is another matter. The member for Dago Martin West, in conclusion, he is offered, if you don't want to be a part of it, say so. We'll stand on principle and press on. That's that. Madam Speaker, on this question of the freedom of information, let me return to that. This takes us now, just as I identified to you that at the heart of the matter with the pension is about fairness and dignity and service and attracting the right people and not turning off some people from this enterprise because of the way we treat each other. At the heart of the issue with freedom of information, Madam Speaker, I submit something that no one has addressed really is the question of productivity and efficiency in our public administration system. Because the law says, as it now stands, you have 30 days. Fortunately, and I can't all the way criticize, because the statistics show, Madam Speaker, that 95, 85, 96% of the time on each year, the bulk of the requests are met with a favorable response. The person asks for the information and they get it. It is in very small cases, and possibly because sometimes they have political contention and connotation, there are issues around them. You heard from the member for Oropuch East that HDC had refused information. And an hour before the court schedule, they called to say they had a change of mind. Who knows? They maybe had a chance to consult with some other lawyer or lawyers. They might have gotten an independent or third-party advice. Nothing sinister about that. It happens every day. But at the heart of it, Madam Speaker, we have to deal with the question of efficiency and productivity and delivery of service, the public sector that is in particular, and of course, the culture of secrecy that some people are steeped in. Because even in the Malcolm Jones case that we heard about so much, and in all others, when the persons who have to decide whether to give the information or not are making that decision, the minister is nowhere around. Neither is the judge. It is when disagreement and disgruntlement comes as a result of it, then the judge gets involved. And in this parliament and outside, the politicians bringing each other in criticism and condemnation, you will swear that it was a minister who decided and not given you. That might be so, but in a few cases. In the bulk of the cases, the statistics show that the information is given. And to test it, knowing of the efficiency of the management and administration of this parliament. And I have always stood proudly and truthfully to commend the management of the affairs of this parliament. We start at 1:30, and so it is. The speaker comes down the corridor. And the prayer is said, and off we go. This parliament, I am talking about efficiency, Madam Speaker.
Okay, so I think while I understand the broad brush that you're casting, I think you need to bring it into the bill now, please.
To test and to prove and to satisfy myself of the efficiency of this institution that is the Parliament, I filed on the 10th of June a request for some information from the Parliament. I submitted it promptly on the 10th of June, 2019. Instant. And I got a reply, Madam Speaker. I asked, Madam Speaker, to share with me, I asked the Parliament to share with me some of the questions. I circumvented it nicely. Some of the questions that had been put to them, and because they're closest to me here, I live here. And then the ministry not far from here. Share homes between these two wonderful places. And Madam Speaker, I got the answer. So said, so done. And I want to take the opportunity, with your leave, just to highlight the reason why sometimes the 30 days may not always be enough. There are people who are sitting in air-conditioned rooms, perhaps, with malice on their minds, perhaps, wickedness, almost with a spirit of... Sometimes you wonder if the things they conjure up, if it is designed to cramp the style of the department they're asking, to grind them to a halt, to burden them with research and work so that they can't do anything else. And let me give you, Madam Speaker, and for all kinds of reasons, but then the actors there and citizens are free. But it is up to the department to provide it in the 30 days. Sometimes, most times, as the statistics show, it works, sometimes not, and the few matters go to court in judicial review. Either for to challenge the refusal to give it, so they would have kept time with the law, but the refusal is what is being challenged, and very often, something that has not been said here, a breach of statutory duty by not responding to them within the time mandated by the law. So you have two basic lines, challenging either the refusal or the failure to give the information on time. So they wait for the 30 days. But part of the thing is to conjure up the most convoluted questions. Let me give a couple of examples. A man wants to know, let me give a couple of things. In respect of the contracts awarded during the period January 2015 and August 2015, kindly indicate the procurement processes utilized. That will call for some research. Another one Capildio Bisoon of 54 Helen Street, Lange Park, Chaguanas. Telephone number 392-1716. He asked the Parliament to give him all Prime Minister's questions which have been submitted by members of Parliament for the period September, and I take members of Parliament to mean both Senate and the lower house, for the period September the 23rd, 2015 to March the 22nd, 2019, and have not been approved by the Speaker. Hear the question? You may ask yourself, The public might ask, not you, Madam Speaker, I'm not bringing you in this. But a member of the public might ask, why would someone want to know that? But that, I think, is maybe irrelevant because you don't know what is going on in many people's convoluted minds. All urgent, another one, all urgent questions filed by members of Parliament for the period September the 23rd, 2015 to March the 22nd, 2019, which have not been approved by the Speaker. Well, now that I'm reading Speaker again, it seems to be confined to the House of Representatives. All questions for which notice is required, both oral and written answers, this is the third question,
A point of order.
between the same period have not been.
I'm trying to follow what the Member of Parliament is trying to go with that line of questioning.
What's the point of order you raised?
Relevance, 48.1.
Please continue. Maybe,
Thank you.
Maybe we will follow short.
Listen,
Thank you.
You will follow shortly.
yeah, follow.
Next example, in response to my question from the very efficient Parliament, Devant Maraj
Oh, no.
of light pole number 51, Solid Gold Avenue, Tumpuna Road, Arima, telephone number 657-2620. He wants to know the policy, practice, and criteria employed by the Parliament regarding reimbursable expenses occurred by any parliamentarian. Question 2, a copy of any document detailing the expenses incurred by parliamentarians which are reimbursable to the Parliament. That now I understand to mean both Senate and the lower house. 3, a copy of any document detailing the policy, practice, and criteria for claiming reimbursable expenses by parliamentarians. 4, a copy of any document detailing the special arrangements which are made to treat with accommodation and other associated
Member for
expenses.
Laventille West,
My lady.
your original speaking time is now spent. You're entitled 15 more minutes. If
Thank you very
wish
much.
To complete, please proceed.
Thank you very much. And then I have, Madam Speaker, another round, another 2 questions from Devant Maraj, same address, same phone number, and a list of others, it continues. I am only demonstrating, Madam Speaker, that nothing that we propose here today interferes with the core philosophy of the law of freedom of information. All that happened here was an adjustment to deal with a particular problem. And Madam Speaker, we cannot pretend in this country, Madam Speaker, in this country, the then Solicitor General, Madam Donaldson Honeywell, pointed out in a letter which is now on the public record to the Prime Minister at the time that there was an unholy alliance, I call it an unholy triumvirate, between 3 elements. 1, the office of the Attorney General, private lawyers, and prisoners. That is now being investigated, and I don't want to go too far, but it is on the public record. An unholy triumvirate. The Attorney General was Anand Ramlogan, and the lawyer was Gerald Ramdeen, a former senator. Fact. The world knows that. And the point, Madam Speaker, is this. We are trying to deal with a situation where I have detected an unholy triumvirate as well. Because you would have heard from the Attorney General and the Prime Minister who spoke earlier that we have a situation here where freedom of information questions are filed. The state or the agency has 30 days to respond. They wait after filing convoluted questions that could take years. I could have given you more examples. Could take far more than 30 days to unearth, to find records, to get files. They wait on the 31st day. Bam, they file the action in the court. So you have the person filing the question, one element of the triumvirate. And then you have the lawyers who are waiting now on the 31st and 32nd day to go to court immediately. So sometimes the state now is able to produce the information in 45 days. And by the time, as may have happened with the agency coming from the lips of the member for Oropuch, well, in this case, they changed their view. But they may have the information now, after the 31st day. And they're ready to submit it. It now moves up, and they're ready to submit it. By which time the matter is in the court. So the lawyer's smiling. You want to withdraw the case? There's a cost. And we heard today about claims. They make claims, exorbitant claims, for as much as you heard today, Madam Speaker, of $1.7 million. And I heard the member for Siparia saying that is not so. You're casting aspersions on the court. Because at the end of the day, it is the court that will tax the bill and decide how much cost would actually be paid. The Attorney General, when he spoke, wasn't speaking about that. He was speaking about the claim. So you have two arms of the triumvirate. And then, of course, when the government, in its attempt, as we are doing now, to protect the public money and the public interests, as we have done in respect of the triumvirate that Madam Donaldson Honeywell identified. So the matter is with the police now. When we come to the Parliament, I had to sit here many times, and I hear the member for Siparia sitting here as the member for Siparia, but reminding us that she is senior counsel and telling us right here, I will take you to court. That is not as a member of Parliament, that is as a lawyer, senior counsel. And I've heard Gerald Ramdeen stand up in the Senate, it's on Parliament record, and talk about UNC lawyers, better than PNM lawyers. So I don't know what the member for Oropuch is telling us today. So when we come here, as we have today, Madam Speaker, to fix the problem in the protection of public money and in the public interest, as we must, we meet the lawyers on the UNC side, the third arm of the triumvirate in this Parliament, to obstruct it and to take objection to it. And then the member for Siparia shamelessly. That simply means without shame.
No, she really have no shame. Oh. Shamelessly is not a bad word.
Amatil West, please.
Thank you. Come to defend and to say that nobody is milking the treasury. But as has been said before, their milk runs so thick and so long, and the breasts of this Trinidad and Tobago cow, Madam Speaker, so lavish, they can't tell when it's too much. If this is not milking, then what is? But the member for Siparia got up here today to try to convince us that there is no milking. And not for the first time, you know. Not for the first time. Not for the first time. Madam Speaker, I'm being disturbed by a very raspy voice coming from on my right here that I would be accustomed to hearing if I was looking for milk. Trying to defend the milk, Madam Speaker. But they have to understand that when this PNM government is at the wicket, the milk will flow, but to those who deserve it and work hard for it and who are entitled to it.
No others for you.
Madam Speaker. So, Madam Speaker, we, understanding the problem, came to the Parliament, and a number of organizations, including the Law Association, and I could speak out of the Attorney General's office. There are many occasions when we are passing laws and we write the Law Association of Trinidad and Tobago for information, for their comments, send them a copy of the bill. 1 year later, we ain't get it yet. We ready to come to Parliament, we ain't get it yet. But they jump out on this occasion. When it's time to stand up and speak against some elements of the triumvirate, not a word from the Law Association. And I heard the member for Oropouche East talking about the Southern Bar, and he called the name of some lawyer. Not a word. But on this matter, everybody jump in. Many of them perhaps being misled by the member for Sipari and the member for Oropouche. So, Madam Speaker, we came to this house to fix this little problem. We recognize all the noise and all the uproar. Our feeling is the same. The policy of the law is the same. We never interfered with that. I heard the member for Siparia talking about it is unconstitutional and threatening to go to court as well, as always, to complete the arm of the triumvirate. So for me, I see a ganging up on Trinidad and Tobago. Constantly using hats and offices in order to do that. But Madam Speaker, Trinidad is a blessed land. And as dark as the days might be, the bright morning would always come. And it came in 2015, and it will come again in 2020, and it's going to come again in 2025. Just say so. So, Madam Speaker, we commend these measures in light of some of the outbursts and some of the comments. We take everything into account in this democracy. We have decided rather than to pursue the 90-day extend the time from 30 days to 90 days, we will do like Canada. Canada had a case where the Constitutional Court imposed an 18-month mandate on the criminal justice system to resolve criminal matters in 18 months, rather than the 48 months they took in the case of Aaron Johnson. And the Canadian government, and I spoke to a couple parliamentarians from that land, the government spent millions of dollars trying to make the system more efficient to cope with that 18-month mandate. Sadly, in the case of capital matters and the death penalty, in 1993, the Privy Council gave us 5 years to deal with that issue in Pratt and Morgan, and we still have not been able. So, Madam Speaker, we've made the adjustment, and we will work to try to get the public officers, and I must compliment them in the Office of the Attorney General. I went through the process. We are very able people, and the mandate is, the PSs have been told, once a request for freedom of information comes in, deal with it immediately. Some departments are larger and can afford the staff and others. Some are more efficient, like the Parliament than others. But, Madam Speaker, the idea is to get to it and try to stay within the 30 days. In those circumstances, for the time being, we'd settle on 30 days. But to strengthen the process by involving the Attorney General, as the court suggested, we feel it is a good move, and we'll stand by that for the time being. And we stand by our proposals on all of the measures in this miscellaneous bill. In particular, we feel that the time has come and gone when we should make the adjustments to the pensions calculation. And I so submit for the support of this House, Madam Speaker. I thank you.
Thank you, Madam Speaker. Madam Speaker, I'm very happy to join this debate. And I want to begin by picking up on a point that was made by my colleague, Dr. Moonilal, the member for Oropouche East, when he spoke about the 47 organizations that have expressed some very strong views about this particular matter, which was addressed by the member for Laventille West a little while ago, the matter of the amendment to the Freedom of Information Act. Madam Speaker, you cannot be a government that proclaims to be a good government and to speak about good governance if you ignore the opinions of your citizens and what has become to be called civil society. Civil society cannot and must not be ignored. This is not the era of the 1950s and 1960s where, you know, a prime minister will get up and say, if you don't like it, get the hell out of here, or not a dog bark when I speak. This is an era in which people are much more empowered in terms of their rights, their freedom of expression, but also the freedom that they believe they should enjoy and by right should enjoy with respect to information regarding how they are governed. Madam Speaker, governance is good, and governance can only be described as good governance if it is inclusive. And that means inclusive of the opinions and the views of the smallest man, if you wish me to use that word, in the society. And that might include the very knowledgeable children we also have in the society who are very much part of this debate that is taking place. And you'll be very surprised to see some of the opinions that are being expressed on the Facebook by very young people about how they feel about this amendment to the Freedom of Information Act. Many feel it's a trampling upon their right to information. Madam Speaker, this debate, therefore, is a debate about transparency. It's a debate about accountability. And the citizen, he is not or she is not sitting in Parliament. She can't or he can't get up and ask questions like the opposition asks. But they can use instruments and institutions like the Freedom of Information Act in order to secure the information they need in order to empower themselves and be a better citizen in the country. When someone seeks information under the Freedom of Information Act, I don't think it is that they are being mischievous. I don't think that they are being malicious. I really do think that people live in an era now where they want to know, and we must not prevent them from knowing, Madam Speaker. Madam Speaker, you see, we must remember, as elected members of Parliament, we must remember as members of the government, that we were elected to govern for and on behalf of the people. And to ignore civil society and to ignore the people and the people's voice is to invite into our society social conflict and a level of social dissonance that can eventually turn into something worse than simply social conflict or the conflict between different minds. Madam Speaker, I would like to have a clarification on the matter of the pensions aspect of this bill as to whether former members of Parliament, like in the era of Mr. Trevor Sudama or others in that era, would they benefit from the amendments that are being proposed in this bill? Because, you know, one of the members on the other side spoke very extensively, I think it was the Prime Minister, and about...
who are still alive, who are legislators, in receipt of a pension, will benefit.
Even if they took option 2?
All persons will benefit from an improved pension.
I would like Honourable Member for Digo Martin notice, and I say this very sincerely, that in your winding up, that you may take an actual example and present it to us as to what will be the difference between where the member is today and where the member will be with the legislation that you are proposing. I think it's a good thing to illustrate what is going to happen. I'm not going to suggest anyone. You said people from in the past came to you. You may want you have the information, but I'm not going to interfere in the private affairs of any particular citizen, Madam Speaker. I'm not going to do that. Madam Speaker, on the matter of the claims being made on the other side about the sums of monies that have to be paid when people go for judicial review as a result of not receiving information. Madam Speaker, there are two sides to this. There is the side where the Attorney General is saying, it can come to me and I'll give you a yes. But there's the other side. And it's a very serious thing to me. It is about competence in the public service. Madam Speaker, it is about competence. Madam Speaker, I think
here, honorable members, I know we're going a little later than people anticipated, but we'll have tea. We'll have tea at 5:30, and any member who can't wait till then is invited to take, to leave a little earlier. Member for Tabaki.
Give it the example of the old time.
yes, Madam Speaker. So I hope that the member would in fact give an example. An example. Maybe you could take two. Maybe you can take, Mr. Overrun Padma on one side, or Trevor Sudama. He can do whatever he wishes. He said that people approach him. He said, well, as a member from the opposition, well, they have the information, but maybe he could provide it to the public. Madam Speaker, I was speaking about the competence of public officials, Madam Speaker. Madam Speaker, there's a malaise in the country. Let's face it, there's a malaise in the country in the public service. I cannot for the life of me see why within 30 days you have all the files and you cannot find the information to provide within those 30 days. Madam Speaker, I really can't see why that can't be done. And the Attorney General is asking for 45 days. Madam Speaker, I am for 30 days. I think 30 days has been adequate. I think 30 days. If you continue to give this kind of leeway, what you are going to do, you're going to encourage incompetence in the society, and you're going to build in incompetence in people.
What is incompetence?
Northeast. Member for Diego Martin, Northeast. You will cut such a better picture if I saw a profile rather than your back. Member for Tabaki.
Thank you. Madam Speaker, we must not be a parliament that legislates for incompetence in the society. Whatever we do must always lift the bar. And the country is crying out for better public service. The country is crying out for a greater level of timeliness and speed and in terms of delivery. And this is an opportunity for us to prove it. So to go back now and say give 45 days and what have you, I think that's rolling back the clock. I think that's rolling back the clock, Madam Speaker, especially in an era when you have so much technology available to you to have the information at the tip of your fingers. What it is that people are fearful of giving information. What it is. You cannot promote the idea of transparency in government. You cannot promote the idea of democracy. You cannot promote those ideals and then deny information or lengthen the time or seek to delay information. You cannot do that, Madam Speaker. Madam Speaker, the matter that I wish to address now is the matter of the amendment to the Central Bank Act that is being proposed. Madam Speaker, I think there is much more to this amendment that meets the eye. And I will ask some very pointed questions to the Honourable Minister of Finance and the member for Diego Martin Northeast, which I hope that he will address, and address in a very serious way and not in a very flippant manner that sometimes he tends to do. Madam Speaker, I just want to establish some base about the central bank. The central bank is an old institution in Trinidad and Tobago. It is almost 55 years old. And when it was formed on December 12, 1964, by Act of Parliament, it was given a mandate, which remains up to this day the mission of the central bank. And you will see where I'm going with this, Madam Speaker, in a while. The bank shall have as its purpose the promotion of such monetary, credit, and exchange policies as will foster monetary and financial stability and public confidence and be favorable to the economy of Trinidad and Tobago. I think that is important. It is important to note that again. The promotion have as its purpose the promotion of such monetary, credit, and exchange policies as would foster monetary and financial stability and public confidence and be favorable to the economy of Trinidad and Tobago. So while the Minister of Finance and the government are responsible for fiscal policy, which is the raising of revenue through tax measures and tax amnesties and what have you in order to fill the shortage of cash in the system so the government can carry out its work. On the other...
This is not anything to do with monetary policy, fiscal policy, or credit, or banks, or anything. It's simply employment at the central bank.
And I'm going to give him a little leeway to weave it in. Yeah. He just shows me that he will, the honourable member, that he'll very shortly show me where this is going.
Unlikely.
Madam Speaker, I will say it right here and now. Right here and now. Madam Speaker, there is across the world a conflict between central banks and ministries of finance and their ministers. And Madam Speaker, it's a very serious conflict because I will point out to you in several places, including Latin America as well as recently in India, where the Reserve Bank of India also had a conflict with the Modi government. I'll point out to you, Madam Speaker, and you will see that if central banks and their staff at any point in time feel very fearful of their positions and their independence of thought and expression, it could compromise their ability to be the kind of institution that guides the economy in the country. That is the point I'm going to make, Mr. Minister. Mr. Minister, that is the point I'm going to make. I just want to make my position very clear, my personal position. I believe in transparency. I believe in transparency. And I do not see why a senior official of the central bank should not be, the country shouldn't be able to know what a person earns in this society. I see no problem with that. But I see a problem when, according to the Central Bank Act, I see a problem when the minister, under the Central Bank Act, he already has the ability to get information from the central bank. Under Part 6, there's a section of the Central Bank Act, relations with the government. And in that section, it says here that the central bank shall, within 3 months after the end of each financial year, cause to be made and to be transmitted to the minister a report dealing generally with the operation of the bank during the last preceding financial year, and B, a copy of the annual audited statement of accounts certified by the auditors. It also says the minister shall, as soon as possible after their receipt, A, cause a copy of the report together with the annual audited statement of accounts thereon to be laid before Parliament, and B, cause a copy of the annual audited statement of account to be published in the Gazette. We're talking the bank shall once every week cause to be made out and transmitted to the minister a statement showing assets and liabilities, and every such statement shall be published in the Gazette. Madam Speaker,
the specific amendment deals with salaries and matters of employment, not credit, not affairs, none of those things. None of those things.
The autonomy of the officers to do that.
Please proceed.
thank you. Madam Speaker, in the Act also, it is also said here, the governor shall keep the minister informed of all developments and activities which affect the business of banking and the business of a financial nature in Trinidad and Tobago. And if that includes personnel and the behavior of personnel, if that includes, for example, the competence of the inspector of banks, then the governor has to provide that information to the minister, right? So the minister in those meetings, he can ask these questions. But so why does the minister want it in legislation? Why does he want it in legislation to get that information? Mister, I'm not necessarily saying you're wrong. I'm not necessarily you're right. But I'm asking the question because I think it's very important to ask it. You see, because this matter of central bank independence is something that is very important. You see, central banks everywhere are struggling to stay above politics. And in December of last year, the governor of the Reserve Bank of India resigned just weeks after the government moved to exert more control over the Reserve Bank of India regulatory powers and how to use its excess capital. So, in fact, in July of last year, if you remember, Donald Trump, the president of the USA, began criticizing the Federal Reserve's interest rate increases. So when you are asking for all this information...
Speaker, Standing Order 48.1. This is not about fiscal policy or monetary policy. Please.
He's making a point.
So remember, if you could just tie it in quickly to the point I think you're trying to make, and then you can move on.
Madam Speaker, it is very important that the independence of certain institutions in the country remain independent. It's very important. And Madam Speaker, I want to quote. Why? From a document produced by the Council on Hemispheric Affairs, November 2nd, 2017, reassessing central bank independence. Central bank independence becomes especially crucial in cases of high government expenditure and fiscal debt. For example, a government could be running a persistent fiscal deficit because of a lack of tax revenue, increased spending, and an inability to secure funding from creditors due to their damaged perception. If there's a lack of central bank independence, the government could turn to the central bank in order to secure additional financing in what is known as an act of fiscal dominance. Madam Speaker, the Treasury will then sell bonds to the central bank, enabling them to print money to fund the government deficit. And that happened in Peru in the Peruvian crisis of 1986 under the then President Alan Garcia. And the country's inflation went skyrocketing. A role of the central bank is to keep inflation in check. And they do that through monetary policy.
Speaker, standing order.
So, Member for Tabakit, I've given you a lot of leeway concerning what I thought you were trying to develop. Okay, so that unless you can tie what you're talking about to the amendment here, I will have to insist that you vacate that point and go on to another point.
Madam Speaker, there's a perception that the amendments might be designed to create undue influence, right? And pressure upon officials of the central bank. That is all I'm saying.
Madam Speaker, Standing Order 48.6.
It is by giving out information.
Member for Tabakit, I will allow you to go on.
Madam Speaker, thank you. Madam Speaker, as much as there is public service underperformance, which requires stern intervention of government, there is also the question of executive overreach, which requires the intervention of the citizenry. And we stand on behalf of the citizenry here, where we feel that there is an executive overreach. Madam Speaker, and I want to say that in this way, what is of great concern to me is that when the institution is a subject of executive overreach, and that overreach is one in an institution that is supposed to enjoy a degree of independence, given its strategic importance to the management of the financial health of the country, as well as in providing...
If we're talking about a particular kind of amendment here, if you could tie what you're talking about, the overreach and the independence, to that, I will allow it. But I'm not seeing you're failing to do that. You're talking about the things in an isolation.
Madam Speaker, I think that when you seek this kind of information as required here, you're going to drive fear in the minds and hearts of people working in the central bank, and you're not going to get that kind of independent analysis.
Okay, so member for Tabakit, I think you could put that another way. Okay, I think you can put it another way.
You're going to compromise the ability of people to feel and act independently at the level of the central bank. Madam Speaker, no professional in this country in an independent institution should feel intimidated or should be afraid to voice their opinions, as well as to share opinions with the general populace.
Speak truth to power.
And therefore, that's what I'm saying. I'm afraid that the worrying concerns in the amendment proposed by the Minister of Finance. I'm therefore left to wonder why the minister, why the sudden haste by the minister to crave this particular amendment. Why? And he has to present to us a convincing argument as to why he wants this amendment. And so far, he has not presented a convincing argument. I want to ask, is there a situation of which we are unaware between the government and the central bank that warrants this amendment? Is there a situation? Is the minister willing to say whether he's at loggerheads, for example, with the governor of the central bank? Recently.
Ridiculous.
And I'll uphold it. I'll uphold the objection. Member for Tabakit, so if you could withdraw that and continue, please.
Madam Speaker, I withdraw it. I said, Madam Speaker, have I finished my line?
Member for Tabakit, I'll need you to expressly say that so the record could reflect it.
Yeah, well, that's what I said, Madam Speaker, and I was going to say, I withdraw. I was being respectful to the chair. I just didn't want to say I withdraw.
Yes.
But, Madam Speaker.
Madam Speaker.
Yeah.
Madam Speaker.
Madam Speaker, I withdraw.
Thank you.
Madam Speaker, there was in the newspaper a situation where the governor of the central bank expressed an opinion that it will cost $620 million to support the Venezuelans in Trinidad.
Madam Speaker, Standing Order 48-1.
But he's making a point. He's leading, you don't.
Member for Tabakit, I uphold the objection.
Frivolous.
Madam Speaker.
Yeah, you're talking about 620 million.
Madam Speaker, the minister came out and disagreed publicly with the governor of the central bank. I am just asking.
It's a fact.
Speaker, point of order, 48-1, 48-6. He's ignoring you.
Member for Tabakit, when I said I uphold the objection, it meant I agreed with the Minister of Finance.
Yeah, I understand that. Thank you, Madam. I understand. Madam Speaker, so but I'm still not convinced that the minister has given me a cogent, comprehensive understanding of why he wants these amendments to the legislation. Because you see, it goes further than just clause, the amendments A to E. 7, under section 9 of the bill, section 9, clause 7, subsection 7, sorry. A request under subsection 1 may relate to a period before the coming into force of that subsection. But before that, it says, such other matters relating to the employment of staff as the minister thinks fit. These are wide powers. These are wide powers. And what are the consequences of if people feel that their privacy rights are being trampled upon? Where is the protection for people in terms of privacy rights? Or is it now that this kind of amendment is going to be placed in other bills where the total information of any person working in the public service could be also requested like this? Are we going to see a spate of amendments in this kind of way, Madam Speaker? So, Madam Speaker, these are basically my concerns, the central bank independence. I see, that they do two things, fiscal policy, monetary policy. We need to allow the people not to have fear in terms of what they propose to do. Madam Speaker, the retroactivity also is something that is concern for me. And I hope in the members winding up, the member will in fact seek to explain some of these things. I thank you.
Yeah. Member for Faisalabad.
Thank you very much, Madam Speaker, for the opportunity to join this debate. The miscellaneous provisions, tax amnesty, pensions, freedom of information, National Insurance, Central Bank, non-profit organizations, Bill 2019. And Madam Speaker, I intend to address a few issues in the matter of pensions and will speak specifically to clauses 3 to 6 of the bill And as I look at the explanatory note of the bill, I just wanted to point out to the Minister of Finance that it really should have been clauses 3 to 6 rather than clauses 4 to 6 of the bill that I have in front of me. Madam Speaker, before I go into the clauses, I just want again to address the issue of miscellaneous and to point out that the Attorney General in a press conference, which was reported on Tuesday, 11 June 2019, attempted to justify the use of the term miscellaneous with regards to this bill. And if I may quote, the AG is reported as saying a miscellaneous provisions bill is not an unusual type of legislation. We agree with that. It is legislation which involves tackling the amendment to several laws all at once. But the AG comes down to say that this is a very time-consuming process. And Madam Speaker, I just want to indicate that we on this side are very prepared to spend the time if necessary if these bills were to come separately. So I just wanted to make that point, that we're prepared and able and willing to do that, and really to not have that as an excuse for calling this a miscellaneous bill. So in fact, this is a very, very miscellaneous bill, Madam Speaker. But I also want to state that, in my opinion, 5 days. In my opinion, that this is what I would call a carrot and stick approach as well, in terms of bringing this, all of these clauses under miscellaneous bill. And I will illustrate, Madam Speaker, because we have the sticks mixed here with the carrot. So the bill seeks to provide a tax amnesty in relation to certain revenue laws. Some may regard that as a carrot that has been handed out to the population. The bill seeks to amend the National Insurance Act, which some might regard as a carrot. But the bill seeks to amend the FOIA Act as well, Madam Speaker. I know a lot has been said about this, but I just want to add just my 2 cents from a different perspective, and that is with regards to the importance of the FOIA with regards to providing medical information. And I speak here from a personal perspective as chairman of the Southwest RHA, Madam Speaker, in terms of the requests for medical information being provided quickly. And I say this because this is one of the avenues in which patients who are grieved by the system, by the care they have received, it is one of the avenues that they're able to get information. And this information is not always sought because they want to necessarily take legal action. Sometimes the information is sought so that they can get closure in terms of unfortunate circumstances, be it the death of a loved one, something has gone wrong in pregnancy and so on. And therefore, I think it is very important that the government consider carefully before they make any adjustments to this act. I just wanted to make that point. And I think, again, it's important that the heads of organizations can ensure that those who work under them, the management and so on, can put things in place to ensure that this information can be provided in a timely manner. And therefore, one would have to wonder really whether this extension is necessary. So I wanted to make that point, Madam Speaker. So, Madam Speaker, I really would like now to focus a bit more in terms of clauses 4 to 6 of the bill. And I did mention already that we're talking about the various acts. But I want to raise the issue of pensions in a very holistic manner and to ask the question, what kind of society do we want to live in? And, I want to say, Madam Speaker, in a modern civilized society such as ours, it is generally agreed and accepted that compensation should be given to those who provide services to citizens on behalf of the state. I think that's well accepted. It's an important principle by which all governments, all administrations, all countries, all states operate. And if I could say further, that this compensation generally takes the form of salary and other benefits. And I know that we are not speaking specifically about salary here today, but I talk about the other benefits. And usually attempts are made to ensure that this compensation is adequate for the services provided. And I make that point in light of the Prime Minister's contribution earlier, in terms of trying to attract the best people to fill our places on the bench and in the parliament. So it should be, adequate for the services provided. It should also be fair across the society. It should be comparable to that in similar countries and similar jobs. So that is also important, that we compare what is, is available in other jurisdictions. And, Madam Speaker, the Attorney General made a very important point, and I quote, we did not sign onto this job for money. I'm making that point simply to state, and again, with the greatest of respect to all of my colleagues presently here in this House and those who have served in the past, we, as MPs, it's a tremendous job. Perhaps it's a job that cannot be compensated adequately. And I'm happy that that point was made, that we did not sign up in this job for the money. I come back to refer to that again a little bit later on. But of course, as much as we would want to provide adequate compensation and appropriate pensions and so on, these are limited really by what a society can afford. So I want to take this whole issue of pensions in the context.
Honorable members, it's agreed that we'll take the suspension for tea now. We will be back here at 6 o'clock.